Hello, everyone, and welcome. Thank you all for being here. Just a couple of housekeeping things. First of all, my name is Michael Hurd, and I am the editor-in-chief of the St. Thomas Law Journal. Bathrooms are right back behind the staircase here to the right next to the elevators. We'll have refreshments going all morning, and then we'll take them away right before lunch. So feel free to help yourself. I want to say thank you to Quinn McCush, who is our symposium editor and has helped coordinate a lot of this. Thank you to Professor Michael Paulson. He has been huge in organizing speakers, and he's really been our point person this entire time, so thank you to him. And most of all, I want to say thank you to our speakers. Without you, would not be possible. We're so grateful. We know, you came from far away and took time out of your day and out of your week, and so we really appreciate it. So thank you. And with that, Professor Michael Paulson will do a quick introduction.
Thank you, Michael. On behalf of University of St. Thomas School of Law and the faculty and the Law Journal, I want to welcome all of you. Most of our audience, as is often the case, is the Law Journal students. Nonetheless, even though you're often suggested, encouraged, coerced to come here, I think this is a really good program and it'll be a great time. So welcome to you as attendees. Welcome to, there's going to be some members of the bar coming in, getting CLE credit. And welcome, a special personal welcome to the participants in this program. My personal thanks to all of you for attending. Many of you are longtime friends. Dan Farber and I have been friends for 35 years. Some of you have been friends of mine, new friends, for 35 minutes or so, and we're all just delighted to have all of you here. The title of the Law Journal Symposium is The Constitutional Rights of Lawyers and Law Firms. And the Law Journal has assembled, I think, a truly spectacular group of lawyers, law professors, and luminaries, with some overlap between those categories, to address a number of important issues concerning the constitutional rights and freedoms, and equally important, the constitutional responsibilities of lawyers. The responsibilities of lawyers as a profession to preserve the Constitution. So my task is for about 15 minutes to give more than an introduction, kind of an overture of sorts, sounding the themes or some of the themes that you're likely to hear today. The precipitating event or series of events that inspired this topic was, of course, the Trump administration's series of executive orders beginning in February and in March, targeting specific lawyers and law firms for special punishments, penalties, and privations because of their representations, who their clients are or who their clients have been, their positions or legal advocacy, what arguments and viewpoints they have put forward in the courts or in public affairs, and what causes they have represented, or targeting them because of their associations, literally who their partners are, who they've hired as partners, or who their partners have been, and the work that those partners have done previously, including serving the United States as public servants in government in the past. These executive orders have been directed at multiple large law firms, sort of big law in the colloquial expression, and they have had ripple effects, however, throughout the legal profession on lawyers practicing in all sorts of configurations, including small and medium, and law firms and public interest organizations and law school clinics. So they began, let me just sort of give you a little sequence of the chronology. They began in late February when Trump's executive order targeted the Washington, D.C. law firm of Covington and Burling, seeking to withdraw security clearances or suspend security clearances of lawyers at that firm that they had had because of that firm's representation of Jack Smith, who was the independent counsel investigating Trump for several of his criminal indictments. In early March, on March 6th, Trump issued an executive order against the Seattle-based and D.C.-based law firm of Perkins Coie because of its association with Hillary Clinton and its involvement in representation of Hillary Clinton in connection with the 2016 campaign. On March 14th, Trump issued an executive order against Paul Weiss, a major New York firm, based upon Paul Weiss's hiring and association with an attorney named Mark Pomerantz, who was one of the prosecutors involved in the New York State prosecution of Trump that resulted in 37 felony convictions. By March 20th, like less than a week later, Paul Weiss had settled with the administration and agreed to a settlement where the executive order would be withdrawn in exchange for Paul Weiss agreeing to the administration's demands, requests, impositions, and agreeing to provide millions of dollars worth of pro bono legal services to Trump-designated charities or activities. Numerous other large law firms followed Paul Weiss's example and caved or settled in the face of the administration's threat of executive orders. On March 25, the firm of Jenner and Block was targeted for an executive order imposing these punishments because of its hiring as a partner of Andrew Weissman, and I'll read just a little bit of about that in a second. March 27th, the Washington law firm of Wilmer Hale, a Boston, Washington law firm, was targeted for exclusions based upon the fact that it hired Robert Mueller, who was an earlier independent counsel investigating Trump. And on April 9th, Trump issued an executive order restricting the activities of the dangerous law firm of Sussman Godfrey because Sussman had represented Dominion voting systems in lawsuits against Fox News and Rudy Giuliani for defamation in conjunction with the misrepresentations that those persons and organizations made about Dominion voting systems causing the theft, the alleged theft of the 2020 elections. So the Trump executive orders and sanctions typically involved these penalties. They would bar law firms from being hired from by in any agency of the federal government. So they barred the federal government from using these law firms in any way. Secondly, they suspended security clearances of lawyers in these law firms that they otherwise had had on the theory that these were dangerous persons because of their representations of clients opposed to the Trump administration in the past. The third imposition that was typically imposed is kind of the most comical one. It barred these lawyers from entering federal buildings, which, if you think about it, is like these lawyers are prohibited from entering courthouses, federal courthouses, in addition to government agencies to negotiate or represent or discuss matters involving their clients. And then the final imposition that was decreed in numerous forms is probably the most serious, in that the executive orders would lead to the termination of contracts with clients of these law firms. So anyone who was represented by these law firms in any way could not have dealings with or negotiations with or contracts with the federal government in any way. And that was quite a large number of clients' circumstances because of the pervasive activities of the federal government. So the consequence of that imposition was essentially to induce clients to fire their lawyers if the clients have any dealings with the federal government. So lawyers were put in the untenable position of having to either bow to the Trump administration's demands or abandon important clients or have their clients be forced to abandon them. So let me briefly read, do a little dramatic reading from one of these executive orders. So this is actually Trump speaking, at least metaphorically, through the executive order issue. And this is the one directed at Jenner and Block. Many firms take actions that threaten public safety and national security, limit constitutional freedoms, degrade the quality of American elections, or undermine bedrock American principles. This is Trump talking about law firms, not law firms talking about Trump. Moreover, law firms regularly conduct this harmful activity through their powerful pro bono practices, earmarking hundreds of millions of their clients' dollars for destructive causes that often directly or indirectly harm their own clients. Lawyers and law firms that engage in such egregious conduct should not have access to our nation's secrets, nor should such conduct be subsidized by federal taxpayer dollars and contracts. Jenner and Block is yet another law firm, I think this is like the 5th executive order that was issued, that has abandoned the profession's highest ideals. Jenner and Block engages in partisan representations to achieve political ends, supports attacks against women and children based on a refusal to accept the biological reality of sex, and backs the obstruction of efforts to prevent illegal aliens from committing horrific crimes and trafficking deadly drugs within our borders. He goes on to refer to Jenner and Block as thrilled to hire the unethical Andrew Weissman as a partner after his time engaging in partisan prosecution as part of Robert Mueller's entirely unjustified investigation. Andrew Weissman's career has been rooted in weaponized government and abuse of power, and then the executive order refers to the numerous instances of Weissman's dishonesty. So this conference will address really 2 big questions. One is, can he do that? And the other is, what's to stop him if he does? Can he do that is basically the question of, can Trump constitutionally issue these executive orders and have them enforced? It's a question of the content of the law, and several of our panels will address various aspects about the likely illegality of Trump's actions. So the answer to can he do that is very likely no. I think you will hear from many speakers. The second big question is what's to stop him, or who's going to stop him? And that's not a question of the content of the law. It's a question of the force of law, the rule of law. Does law govern, does law rule the ruler, or does the ruler rule over and above the law? And that's a question of institutions and their ability to give practical force or effectiveness within the public sphere to the law. It's a question of the power of courts, of universities, and of the legal profession itself. And we will have representatives of all of that here. Obviously, there'll be law professors from universities. There will be lawyers from the community. We will have a retired federal judge, and we will have legal practitioners. By way of background, of the law firms that were targeted by these executive orders, 4 of them opposed and resisted and litigated the issues. They sued the Trump administration. Those are Perkins Coie, Wilmer Hale, Jenner and Block, and the Sussman law firms. Several other law firms, Paul Weiss and about a half a dozen others, appeased, desisted, and capitulated. All told, the law firms that settled with the Trump administration, sometimes preemptively to avoid an executive order, promised Trump $940 million worth of legal services, pro bono legal services, for causes and issues that Trump would designate as being consistent with his agenda. Many other law firms, most law firms in the nation, said nothing. They remained silent. Others, more than 500 smaller and medium-sized law firms, joined an amicus brief, a prominent amicus brief, in support of Perkins Coie in that litigation, defending Perkins Coie's right of autonomy and attacking the executive orders as unconstitutional. We will have a representative from one of the law firms in Minneapolis who that signed on to that amicus brief, that Sybil Dunlap of the Green Espel law firm. The litigations so far have been successful. Every district court that has entertained these lawsuits has issued an injunction against enforcement of the Trump executive orders. But all of those issues are now on appeal. We invited a representative from Paul Weiss and some of the other settling firms to attend this law review conference, but they declined. They somehow didn't want to come to Minneapolis in November. But who could want to not be in Minneapolis in November? It's sunny and warm. As I tell people, it is always sunny in Minneapolis. We also invited a representative of the Trump administration. We talked to the lawyer who has been litigating these cases on behalf of the government. We weren't optimistic that the Trump administration would actually come, but he was considering it, and I said, well, if you want, you can extend the invitation to Attorney General Pam Bondi too, and that would be fine with us too. But they turned us down also. So the questions this conference will focus on are really variations or specifics of the question of, can he do this? And what's to stop him? We have 3 panels and an interview. That's the format of the conference. The first panel is addressed broadly to the question of the First Amendment rights of lawyers and law firms to choose their clients, their cases, their causes, and colleagues. Is lawyering protected by the freedom of speech? Is lawyering an aspect of expressive conduct? Is lawyering free speech, in addition to being a professional activity? Are law firms expressive associations with the ability to choose their own membership, their own clients, their own causes, and to advance the positions they wish to have advanced? After a break, our second panel will look at how these Trump executive orders and other policies of the Trump administration are, as a practical matter, affecting the right to counsel and how they impact on lawyers' professional independence, on lawyers' ethics, and how they affect the legal system as a whole. If his plane arrives on time, during the lunch session, I will be interviewing Michael Ludig, a former judge of the U.S. Court of Appeals for the Fourth Circuit, who has recently become a prominent critic of the Trump administration. Michael Ludig was my boss at Department of Justice before I became a law professor, and I haven't seen him in 35 years. And we will have a conversation in which the audience will be able to participate and ask questions to. And I think for almost all of these panels, the audience can pose questions. The last panel of the afternoon will be, it's entitled, "The First Thing We Do, Let's Kill All the Lawyers," which is a quotation from a Shakespeare play. But the theme is government coercion and the role of lawyers in preserving a free society. Beyond the constitutional rights of lawyers, what are the duties of lawyers as public servants, as members of a distinguished profession, to resist encroachments on the Constitution? Do lawyers have a vital institutional role? So that's the plan for today. Let's get that first panel up here. Thank you all for attending, and we'll be back in a few minutes.
Good morning, everyone. My name is Professor David Granardo. I'm a professor of law here and the Associate Director for the Holleran Center for Ethical Leadership in the Professions. The title of this first panel is "The First Amendment Rights of Lawyers and Law Firms to Choose Their Clients, Cases, Causes, and Colleagues." I'll be giving a very brief introduction of our panelists and our commentator. You can find their bios in the program. All three of our panelists are former Supreme Court clerks, and our commentator is a former Deputy Assistant Attorney General at the Department of Justice. So our first panelist who will be talking is Professor Will Baude. He's at the University of Chicago School of Law. He clerked for Chief Justice Roberts. He's at the end. There you go. All right. Our next panelist is Professor Daniel Farber, and he clerked for the late Justice Stevens. He's sitting right next to Will. And then our final panelist, not to be outdone, Professor Kate Shaw, who's at Penn Law School. She clerked also for Justice Stevens. And did I say you're at Cal Berkeley Law School? Or did I already mess that up?
It's fine.
Okay, nice talking to you. Okay. As for me, I had a very successful trip myself to the Supreme Court. At the Supreme Court, I was exonerated of all charges. Most charges. This is not irrelevant. Okay, whatever. So, finally, thank you for those who laughed. Thank you. I appreciate that. Must have been my former students. Our commentator is Professor Helen Norton from the University of Colorado School of Law. I'll give you just a few of her highlights professionally working as a lawyer. She was the former Deputy Assistant Attorney General for Civil Rights at the U.S. Department of Justice. She also served on President-elect Barack Obama's transition team, and she also served as the Director of Legal and Public Policy at the National Partnership for Women and Families. This is an incredibly impressive panel and commentator that we have for this first panel of the day, and here's the format. There will be 15 minutes for each panelist to present. That'll then be followed by the commentating by Professor Norton. What that means is she'll be judging every word that the panelists say, and then she will be giving 10 minutes of commentary. That will be followed by Q&A. The Q&A will most likely consist of a few inartful questions by me, and hopefully, this is what I really hope for, questions and comments from the panelists on each other's presentations. And certainly it will include any and all questions that the audience has for our wonderful panelists and for our commentator. And with that, I'll hand it over to our first panelist, Professor Will Baude.
All right. Thank you for having me. Thanks to all of you for being here. Thanks especially to Mike for convening us all. I thought I would kick off, actually, with the question that Mike Paulson asked me when he first invited me to come speak at this symposium, which was, don't you think these law firm executive orders are the most unconstitutional thing this administration has done so far? Now, I don't remember the date of that question, which might be very important because time happens fast in this administration. But even at the time, I'll tell you, my immediate answer was no. No, the most unconstitutional thing this administration has done so far is the birthright citizenship executive order, which directly contravenes an explicit provision of the Constitution, as well as liquidated constitutional practice on a topic where the president has no authority anyway, citizenship and the jurisdiction of the United States. That's the most unconstitutional thing the administration has done. And then I thought about it a little more, and I thought, well, maybe the second most unconstitutional thing the administration has done so far would actually be the suspension of the TikTok ban. Congress passed a law by bipartisan majorities that was upheld as constitutional by the U.S. Supreme Court on an emergency basis. And without even purporting to find the law unconstitutional, the administration just announced that it's not going to enforce the law, which violates the constitutional obligation to take care that the laws are faithfully executed. And worse, the administration's also promised, or purported to promise, that nobody can be penalized or held liable for their actions during the period of the purported suspension, even though there's no power to suspend the laws. The lack of a king's power to suspend the law is one of the central premises of the U.S. Constitution's no kings rule. So whatever the limits of the Take Care Clause, granting get-out-of-penalty-free cards for constitutional laws enacted by Congress is the opposite of the president's obligation and the opposite of the power the president has. But the law firm executive orders might be more important in a different way. The law firm executive orders are, in important respects, not like the birthright citizenship order or the TikTok ban suspension, because they involve the use of real executive powers. The president really does have power over security clearances and government buildings and so on. So what they represent is the abuse of a real power rather than the assertion of a non-existent power. But in this respect, they're actually much more emblematic, much more representative of a lot of the unconstitutional actions that have been common in this administration. I think one of the distinctive patterns of the Trump administration, especially the second Trump administration, is the use and abuse of a broad range of constitutional and statutory powers to reward the friends and punish the enemies of the regime. Indeed, some conservatives, including some of my former students, have argued explicitly that this is what a modern conservative government has to do, that if you, quote, know what time it is, you will know that it's time for the government to be using its powers to reward its friends and punish its enemies. So I think it's time to talk about that. As you know from our overture, from our host and major domo, some law firms have been on the receiving end of threats from the Equal Employment Opportunity Commission, from other branches of the government, focused on a wide range of things. And in particular, a set of executive orders dramatically targeting several law firms are explicitly and obviously premised on the fact that the law firms are or harbor or represent enemies of the regime. Covington and Burling was punished for representing Special Prosecutor Jack Smith and employing people who worked in his investigation. Wilmer Hale was punished for having once housed Special Counsel Robert Mueller and for hiring 2 lawyers after they worked in the Mueller administration. General Block was punished for rehiring a Trump enemy who'd worked in the Mueller investigation. Perkins Coie was punished for its actions taken while representing Hillary Clinton, and so on. Again, an important thing is that these executive orders invoke real executive powers. The executive branch really does and sort of has to have authority to grant and revoke security clearances. It has authority to administer the resources belonging to the United States, to make contracts on behalf of the United States, and thus to decide with whom to make contracts. It has authority to enforce the civil rights laws and to direct their enforcement against particular individuals and organizations. All of this is true even on the stingiest views of Article 2. Even if you think Julian Mortensen is right, that the executive power is largely an empty vessel, or John Harrison is right, that Article 2 represents a Whiggish view of executive power, largely limited to deciding how to enforce and administer the resources of the United States. That's what these executive orders purport to do. They're in a sense, in the heartland of real executive powers, things that the executive branch has to have the authority to do. What is distinctive about them and unconstitutional about them is that they are an abuse of power, right? They represent the misuse of real power for improper and illegitimate purposes. I think there are several different ways to see this. One, maybe the most obvious, is through modern constitutional doctrine, which I'm sure I will not be the last person to talk about, where we would say that the orders violate the First Amendment because they retaliate against people and groups on the basis of their speech and protected activities. Under black letter law, if the government takes punitive action against a group because of the views they've expressed, and a person of ordinary firmness would find those actions sufficient to deter them from speaking that way in the future, that's unconstitutional retaliation. It's a form of punishing people for their speech and attempting to stop people from speaking in the future because of their viewpoints within the heartland of what modern First Amendment doctrine forbids. Now, we could peel things back a little further, right? It has been widely alleged that First Amendment doctrine today is maybe more protective of free speech and less respective of government prerogatives than it was at the founding. I think this claim is probably overrated or overstated, but there's some truth to it. But even if that's so, even if you look at sort of what the leading originalist accounts of the First Amendment say, like those by my friend and sometime co-author Judd Campbell, even if that is so, punishing enemies of the regime on the basis of the executive branch's discretion would still have been very unconstitutional, even at the founding. Even on the sort of originalist pro-regulatory premises, legislatures had the ability to regulate constitutional rights for the public good. But first of all, those had to be regulations for the public good. The idea was that the legislature was supposed to have some set of reasons or moral views applicable to all, not the private good, the personal vengeances and opponents and enemies of those in power. That was the core of what the legislature's job was, to consider the public good and not private enmities and alliances. And even on Republican theory, it was the legislature that had the power to regulate rights in the service of the public good, not the executive branch. The executive branch's job was to take care that the laws be faithfully executed. So for sort of two overlapping reasons, even if you believe Adrian Vermeule about the scope of First Amendment rights at the founding, and he does not think they were very broad, even if you believe him, it would have been squarely unconstitutional for the executive branch to use its powers, even its real powers, to reward the friends and punish the enemies of the regime. Now, the abuse of real executive powers for improper ends, rewarding friends and punishing enemies of the regime, is, as I said, exemplary of so much else that the second Trump administration has been doing. I'm sure the examples are obvious, but let me give a few. The administration's war against Harvard University, freezing or revoking federal funding, threatening the revocation of tax-exempt status, and selectively targeting Harvard-related visas and foreign money. The criminal prosecutions of political opponents like Jim Comey and Letitia James for minor alleged crimes that many people are not prosecuted for. Downgrading the press privileges of the Associated Press for refusing to rename the Gulf of Mexico the Gulf of America. I really can't believe I'm not making that one up. The deployment of the National Guard to blue cities because of their perceived hostility to the Trump administration. Pardons for those who worked to subvert the results of the 2020 presidential election or stormed the Capitol on January 6th, 2021. I'll say I paused on this one because I did spend a while trying to figure out, does it even make sense to say that a pardon is unconstitutional? Isn't the pardon power supposed to be a kind of plenary prerogative, which, you know, we might politically criticize for being used to punish your friends or to reward your friends, but the pardon power isn't supposed to be plenary? But I think the answer is no. The pardon power sits in Article 2 alongside the power, the obligation to take care that the laws are faithfully executed. And both of them were understood not to be in tension with one another, but it's understood to be part of the president's obligation to look out for the best interests of the country. So even though it might be hard to review a pardon, for reasons I'll talk about in a second, I actually think some of these pardons may be unconstitutional or an abuse of executive power. Now, the thing that's tricky about the abuse of real executive powers, as opposed to the use of non-existent executive powers, is that it is very hard for the courts to stop this. And it is not clear there will always be successful judicial review. That's the unfortunate answer to Mike's second question. And this is true for at least three reasons. One is a doctrinal reason. Sometimes doctrine explicitly says this is something the courts shouldn't second guess. Security clearances are probably the most troubling example of this. The D.C. Circuit, for a little while, thought that they should probably review whether somebody's security clearance was revoked for an unconstitutional purpose. That seems under Marbury versus Madison, like it might be the obligations of the courts. But then they were faced with a flood of people who, basically everybody whose security clearance was suspended, who then alleged it was suspended because of something they said or something they did that shouldn't be punished. And the D.C. Circuit gave up and adopted a rule that the revocation of security clearances is basically unreviewable. Maybe these cases will cause the en banc DC Circuit to think better of that rule. I don't know. But under existing law, it's very hard to challenge some executive actions when there's a real executive power, issues of ripeness and so on as well. Second reason is a sort of more of a reason of judicial psychology. Judges worry a lot about being called in to second-guessing the motivations and purposes of the executive branch because they're often hard to know and put the judges in an uncomfortable position. Now, you might think they might worry about that in general, but in these cases, the purpose of the executive orders is on the face of the executive orders. So it doesn't take a lot of mind reading to ask yourself, why was there an order against Perkins Coie or Jenner and Block or Covington Burling? True enough. And that might be the reason these orders will be enjoined. On the other hand, judges are cursed with the ability to see one step ahead. So the judges know that if they say, these orders are enjoined because of paragraph 1, there is a decent chance that somebody will reissue the order without paragraph 1 and say, okay, fine. Now how do you think about the order if we don't say that's why we're doing it? And then the judges have to figure out whether they're going to start doing a little mind reading or not. It's a little embarrassing if they say, okay, yes, it's fine to punish enemies of the regime as long as you don't say you're doing it. But it's also a little tricky if you have to start asking yourself in every case, why is the executive branch doing this and are you punishing enemies of the regime? And it's not clear to me that the courts are going to be willing to follow that inquiry everywhere it leads, whether they should or not. And the third reason is a practical reason. Even if there are preliminary injunctions, even if courts are willing to review these things, they often just aren't actually able to stop all of the abuses of executive power. So to quote a lawyer at one of the firms targeted by these orders, who must remain nameless, you can get all the preliminary injunctions in the world, but none of them are going to make the head of the Federal Trade Commission pick up my phone calls. A real part of lawyering for large clients is figuring out how to get regulatory clearances for large transactions and so on. And part of being a good lawyer representing your client is being able to get the government on the phone and talk to them when you need to. The preliminary injunction is not going to do that. It's not going to make the Solicitor General take your meetings about whether or not to intervene at oral argument in your case and so on. The law firms know that. The executive branch knows that. And that's part of the reason that abuse of power is so effective, is that even if it's unconstitutional, the courts may not be able to stop it. So this is a clearly unconstitutional abuse of executive power. It's typical of the unconstitutional actions of the Trump administration, and it may not be easy for courts to stop it, which is the bad news, I think, today. But the last thing I want to say, which is maybe obvious, but I think can't be said often enough, is that even if courts are unable to stop it, even if it turns out that courts can't stop all of the unconstitutional actions of the Trump administration, they are still unconstitutional. And it's important for us to remember that as long as we can. Thank you.
Well, that was terrific. I'm going to be looking at sort of the other half of our assigned topics for the day. Isn't this unconstitutional? I agree with William. It is very hard to rank the administration's actions in terms of which one is the most unconstitutional. And although I might have a couple of others as number 1 or number 2, but obviously the birthright citizenship, and the effort to waive the TikTok ban would be very high on the list. But, as a way of sort of salvaging Mike's question, or the assumption under that question, I would say that although these might not be the most unconstitutional executive orders based on some kind of metric, I think they may be the executive orders that are unconstitutional in the most different ways. Right? If you look at the opinions or you look at the complaints, you see there's a whole ream of different attacks on the executive orders, which by and large were successful in pretty much all of the district court opinions. Although I think the First Amendment claims are probably the most straightforward doctrinally. So in a way, this is sort of a perfect storm because so many different things come together in these orders. So many dimensions of abuse of power. And what I want to do is think a little bit more about the attacks on law firms and try to think of what is the significance of the fact that the targets are lawyers. Because I think at least some of the claims clearly do apply to the law firms, including some First Amendment claims, but not necessarily because they're law firms, right? So I want to think some about where does that really bite in terms of the manifest unconstitutionality of these orders. I also agree with William, the First Amendment issues are much easier in this case because the executive orders are so candid in their unconstitutional aims. And one thing I had thought about talking about this morning, but I think people on this afternoon's panel are going to be discussing is why does the administration go out of its way to be explicit about its violation of the law when they might have taken more subtle actions, just started denying individual security clearances without, making a big show about it. And I think part of the reason is clearly to attempt to increase the pressure on others to cave by making a sort of display of force. But I'll leave that for this afternoon's panels. So I'm going to talk some about the First Amendment, but I'm also going to talk about what I think is an even more foundational value at stake in these executive orders, the rule of law. And the question, I think Mike put it, was, is the ruler subject to the law, or basically is the law subject to the ruler, is the fundamental question. So in thinking about that, I'd like to start with a hypothetical. I'm teaching torts, so I do a lot of hypotheticals on the average day. So this one is that Trump imposes the same penalties, but not on a law firm, on the CEO of a company and the company. And the occasion for imposing these sanctions is that the CEO made the mistake of beating Trump at golf. So just as with the law firms, the CEO and members of the company can't enter any government buildings. They can't get government jobs. Any company that does business with them can't get a government contract, et cetera, right? Now, the limits of the First Amendment are not always crystal clear, but I think it's pretty clear that golf is not a protected form of expression. So we don't really have a First Amendment issue here. It's still an exercise of the executive's powers over who to admit to buildings and so forth. And it doesn't maybe have the same kinds of effects, or some of the same kinds of effects as pressuring law firms has. But I think it's still plain that the action is blatantly unconstitutional, and in fact, seems more reminiscent of Nero or Caligula in one of the mad Roman emperors than it does of what you would expect in a democracy. And what's wrong here, I think, is a very fundamental violation of a norm that goes back really much further than the First Amendment, right? If you go back to Magna Carta, I feel funny talking about Magna Carta because usually crackpot lawyers throw that in somewhere in, their claims. But nonetheless, Magna Carta has the law of the land clause that prohibits depriving anybody of property or life or pursuing them except under the law of the land and subject to the judgment of their peers, right? So it's the very distant ancestor, 600 years earlier, of 500 years earlier. I'm blaming this on jet lag. 500 years earlier of the Due Process Clause, which is probably the most natural place you would look for this principle in the Constitution. But in fact, because it's so fundamental, there are a number of places in the constitutional text or in judicial doctrine where this basic concept of legality, the idea that punishment has to rest on law, not on the arbitrary will of the ruler, comes up in many places. So I think you see it in due process. You see it in the class of one equal protection claims that the Supreme Court has recognized. I think you see it in habeas corpus, which is designed in large part as a protection for the idea in the case of detention that the executive needs to have legal warrant rather than simply a prerogative power to detain whenever it might be in the public interest. And I think there are kind of related ideas that you find in ex post facto and Bill of Attainder, even though they apply to the legislature rather than the executive. So, as I say, this is a very old idea, but a very basic one. Now, what about the First Amendment? It's true that issues of motive are vexing for the courts. They're difficult in the case of the executive, but they've come up in the case of the legislature. The legislature did something for a bad reason initially, maybe a discriminatory reason, but if you strike it down for that, what if they just repass the thing? And, you know, how far are you willing to keep playing that game? Maybe it's not quite as delicate a topic as it is in the case of, you know, when it's the president involved, but it still raises some, I think, real problems for the judiciary. And as William and I has said earlier, that's not really the case here. However, because the executive order is so clearly aimed at expression, either past expression by people who have become parts of the law firm's choice of clients, or, and I think most clearly protected probably, are the law firm's pro bono litigation. But while I think this is a clear First Amendment case, it's a clear First Amendment case that could well have been brought by a bunch of other types of organizations, not having nothing to do with the practice of law, with lobbying firms, with, media, with various kinds of organizations, left and right that advocate for particular positions. And I think it would be equally unconstitutional if a president were to apply the same kinds of sanctions either to, say, the ACLU or, I don't know who, the Heritage Foundation, on different sides of the spectrum. So again, this is another dimension of unconstitutionality, but one that's not keyed to the fact that it's law firms. So what's special about lawyers? Why should we're lawyers, or, going to be lawyers in this room, but why should somebody who isn't think that going after law firms is an especially bad thing? We've heard about the first "let's kill all the lawyers" quote from Shakespeare, which seems to, although I think as with sort of anything in literary text, it's open to sort of endless interpretation, but at least in context, it's placed in the mouth of a revolutionary who Shakespeare doesn't really approve of, and seems to be based on the idea that when they take over, they don't want lawyers because lawyers protect people's rights. Now, he wrote at a time when England was only modestly democratic. The monarch was still very powerful. The House of Commons was beginning to assert itself, but was, not by any means the dominant power in government. The first real defense of free speech, at least that I'm aware of, is by Spinoza, and it was several decades later. Right. So I think what this is telling us is that there is a relationship between lawyers and that rule of law norm that I talked about earlier that is in some ways more fundamental, that can be valued even in societies that are only at best imperfectly democratic, and that have not recognized free speech as an independent value. We also see, discussed in some of the judicial opinions, that lawyers are really connected to the ability of courts to function properly. So there's a separation of powers aspect here. Without lawyers to argue the cases, courts can't function effectively as decision makers. And the court has said that the role of lawyers in asserting legal claims, and they haven't really said it as explicitly, but I think you could say it also in counseling legal compliance, are both sort of fundamental precepts that underlie the legal system. So my bottom line is that lawyers sit at the intersection of the rule of law and the First Amendment, which makes them somewhat unique, at least. There are a lot of people involved in both of those larger sets, but the area of intersection is smaller. And that's one of the reasons why, at least I would be tempted, along with Mike, to put this executive order at the very top, because I think it is an attack not on rights, but on the right to have rights, and the ability to enforce those rights. Thank you.
All right, well, thank you so much for including me in this gathering. It is great to be here, and especially to see a genuinely cross-ideological group gathered for this really important set of conversations. And I'm going to start in the same place, even though Professor Paulson did not ask me the question, do you think this is the most unconstitutional thing he's done? But I, too, sort of was puzzling over that question when I sat down to prepare remarks. So even though Professor Paulson didn't ask me this, I have been asked a number of times over the last 10 months, what do you think is the most unconstitutional thing the president has done? And to my mind, the list is long, but I have responded more than once by identifying the attacks on law firms. And it's certainly not that I think that these attacks are the most consequential when it comes to questions of the basic structure of government or the separation of powers. I'll throw in something that hasn't been mentioned yet, but I think is critically important, which in terms of, sort of the long list of lawless actions, and that is the refusal to spend billions of dollars of appropriated funds, monies Congress has appropriated, or as in the shutdown, the decision to spend monies that Congress has not appropriated. Both of those moves are, I think, far more significant from the perspective of structure and the separation of powers. I do think the executive orders impact courts, and that's obviously a separation of powers concern, but far less so than the impact of these aggressive assertions of spending authority on Congress's authority, and thus the proper balance of powers. Okay, so less important than other moves when it comes to structure. And certainly the law firm executive orders do not even rank among the administration's, I think, lawless actions when it comes to human toll. Right, on that metric as well, I think the spending moves are the most significant. So just as one piece of evidence in support of that claim, the Lancet estimates that the administration's USAID funding terminations could mean that by 2030, so 5 years from now, 14 million additional people will die worldwide. And to be clear, many of the moves that the administration has made on the spending front could absolutely have been lawfully done by Congress. The human toll would have been no different, but they could have been lawfully done, and I wouldn't list them on this panel because as odious as I would find them, they would have been done through the constitutionally prescribed method for changing law, but that is not how they were done. And no one, to my knowledge, has died because of the executive orders that seek to punish law firms because of the positions they've taken and the people they have hired and the clients they have represented. But I do think the attacks on lawyers and law firms are related to all of the other unconstitutional actions the president has taken. So, this echoes some of what's already been said, but for better or worse, in our system, lawsuits and courts are critical tools for restraining official lawlessness. Lots of other things are too, right? Public opinion is, and that's of course largely shaped by the press. There are other important checks, cities, states, civil society, all of those entities have roles to play, but lawyers are among the most important. And for that reason, I think the attacks on law firms have to be understood in the context of shoring up the ability of the administration to engage in lawlessness more broadly, including lawlessness with devastating human toll. So the impact of the law firm executive orders, I think, has to be assessed in the context of other administration actions that the law firm targeting is designed to facilitate. And the other reason that I think the law firm EO stand out is, again, echoing something's already been said, is the sheer number of constitutional violations that they contain. I do think it is not often that government makes a move that is squarely and clearly unconstitutional in 3 or 4 or 5 distinct ways. And you almost have to admire it, right? Like not just the brazenness, but the efficiency. It's hard, actually, to violate the Constitution this many ways in a 2-page executive order, and yet they have managed to do it. And so I think for some kind of combination of those reasons, that is why I think I've named the law firm executive orders a couple of times when I've been asked. But I want to make a point that is in some tension with the second claim I just made about the kind of number of constitutional violations. And that is that in some ways, to divide the constitutional violations that these orders reflect into distinct categories is actually kind of a mistake, right? So, we teach law that way, right? We tackle one body of doctrine or one cluster of cases at a time. First Amendment, due process, equal protection. It's obviously how we draft briefs and legal opinions. It's how we cluster speakers on conference panels. But I do think that kind of atomistic thinking can be a mistake if what we are witnessing is an assault on the kind of very idea of constitutionalism, right? Or at least one idea of it, which is just the Constitution as a set of binding constraints, including constraints on the president. And whatever our disagreements about the Constitution's meaning and how to discern it and who gets the final word on all of that, I think that those of us here do share a belief in the Constitution, whatever its imperfections. And I do think we have seen in the last 10 months an assault on the very idea of the Constitution as a set of binding rules and constraints, at least when it comes to the president. And that is in addition to the discrete constitutional infirmities and, importantly, the flagrant violations of the First Amendment that these orders reflect. But in some ways, these executive orders are actually the easy cases because they happen against the backdrop of judicial doctrine, in particular First Amendment doctrine, that makes pretty clear just how impermissible they are, which is part of what makes the decision of so many law firms not to fight so galling, because they're obviously unconstitutional and courts can see that plain as day. But again, these moves fly in the face of existing doctrine. But, and here is a little bit where I'm going in this kind of observation about the dangers of thinking too atomistically, some of these moves have been taken in domains in which there just isn't doctrine at all. They are moves that government has not made before, and so there is not really executive branch precedent, there is not judicial doctrine that has developed, but the moves are still in profound tension with core constitutional values and principles, and just because we don't have a list of kind of doctrinal hooks with cases to support them doesn't make many of these other moves, I think, any less unconstitutional. And so I want to just talk for a minute about 2 other related sets of moves the administration has made, again, one of which has already been mentioned, and that is the attacks on the civil service and the targeting using the criminal law of the president's enemies. And when I'm talking about attacks on the civil service, I'm not talking about the firing of high-level officials, like the heads of independent agencies. There, I think reasonable minds can actually disagree about the scope of the president's power. Our history provides support, actually, although I think it's a very mixed historical record, but for the president's ability to potentially remove heads of independent agencies. Obviously, I think there is a lot of both precedent and constitutional structural arguments that support limits on that presidential authority. But I'm talking about, also not talking about efforts to change the contours of the civil service, right? Move certain officials into and out of, or certain categories of employees into and out of the job protections that the civil service confers. Those are moves that every president since the Pendleton Act in 1883 has made. But I'm talking about the decisions to single out, to terminate, or to subject to other adverse treatment line prosecutors at the Department of Justice, agents at the FBI, officials in DEI offices at the EPA or Ag or Interior. So their firings do, I think, pretty clearly violate civil service laws, but they also violate what is now a well-settled constitutional norm against firing officials based on partisan considerations or pure policy disagreements or personal pique. And since the advent of the civil service, no president has really tried to fire officials for those reasons, so we don't have a developed body of case law in the federal courts about it. We have some cases out of the states. We do have statutes. We have administrative agency precedent from a body called the Merit Systems Protection Board, or the MSPB. But most importantly, we have constitutional norms, and constitutional norm violations are hard to litigate. And whether or not there is a winnable case that these moves violate the Constitution, whether or not courts have the tools to deem these actions impermissible under the Constitution, I think they very much are. I think that's also true about targeting officials for criminal prosecutions because they have crossed or displeased the president. Those are moves that are in profound tension with core constitutional values, due process, equal protection, First Amendment protections against being punished for criticizing the regime. And as some of us talked about a little bit at dinner last night, the case law around vindictive or malicious prosecution is tough. It is tough to satisfy. But whatever that case law provides, I think it is absolutely the case that moves to punish adversaries and reward friends, although that's less likely to sort of end up in criminal court, but not impossible, but certainly punish adversaries, whether or not the case law is really going to provide a winning set of arguments. The principle that our leaders cannot use the power of the state to punish their enemies is a real one. It is a constitutional one. Whatever the case law tells us and whatever a hook sort of may or may not be in terms of litigation. And I think to sort of echo what Will said in his closing remarks, even if that's the case, even if the courts lack the tools actually to restrict the president from behaving in this way, the rest of us naming and recognizing these kinds of actions and practices as antithetical to constitutional principles is still critically important. Even if when we litigate, we have to do it in these tiny bundles of doctrine, I don't think we have to conceive or talk about it that way. Okay, so I'm going to make two more quick observations, both sort of distinct from what I've been talking about. One is related to something that I've been working on with frequent collaborators of mine, Leah Lippman and Melissa Murray, and that is that it is clear that many recent efforts, right, in the last 10 months to increase and consolidate presidential power have come at the expense of independent agencies and of Congress. I think that is pretty straightforward and people appreciate that. What I think is less understood, but maybe equally important, is the way in which this emerging vision of presidential power seeks to appropriate both the tools and in some cases the formal powers of the courts as well, right? So, and here I'm not talking about the attacks on law firms hurts courts because it deprives courts of, lawyers to make representations, but actually something kind of different, which is that this is a fundamentally new form of presidential power and control that both uses litigation as an affirmative tool of presidential power and control, but also it is, this is a little inchoate, so I'm just trying it out now and happy to talk further if people have questions. But I think the administration is engaging in the adoption of new forms of action that essentially involve the creation of shadow legal processes that in many ways mirror but wholly kind of play out apart from existing legal processes. So the president is essentially using these both familiar in terms of actually affirmatively filing civil litigation, but also unfamiliar forms of kind of quasi-litigation to shore up power and to silence dissent. And I think these deals with law firms in which, without a complaint ever being filed, without any kind of adjudicatory body ever being involved, the president and often outside advisors, because the people negotiating these deals, at least in some instances, haven't even been government officials. They have been outside actors associated with the president, negotiating on the president's side of the transaction, have reached these settlements, right? We're using this legal term settlements through these shadow or ersatz legal processes. And I do think that's a fundamentally novel form of presidential power. So we have the president seeking to assert court-like as well as congressional, right? I talked at the outset about spending authority, but court-like powers. And so if the president is asserting court-like powers or judicial, quasi-judicial powers, and also congressional powers, I think we are talking about a vision of presidential power that is not a unitary executive, but in fact is unitary government. And that is fundamentally incompatible with the design of our constitutional scheme. And I'll just end with one final observation, which is I think that all of us who are horrified by these attacks on law firms, and I think the list is long, I think should acknowledge that the difference between the constitutional flaws in the law firm attacks and many of the other related moves the administration has made is one of degree and not of kind, right? So I think that the law firm attacks are maybe worse, but they're not fundamentally different from any of the other attacks. And I say this because I think there has been, not just at this convening, but kind of more broadly in the legal profession, broad cross-ideological support for the firms that have decided to fight and condemnation of the firms that have decided to capitulate. A lot of prominent conservative lawyers and firms have joined in the defense of the firms that have decided to fight, and I commend them for that. But I think that has been less true when things other than our guild as lawyers is at stake. And I think that the attacks on universities, on science, the weaponization of the Department of Justice, attacks on nonprofits, civil servants, some of the targeting of immigrants and the use of the military against peaceful protesters in blue cities. I think all of that is of a piece with the attacks on law firms. And I would love to see the same kind of cross-ideological condemnation of those moves as we have seen of the moves against law firms. And so with that, I'll stop. Thank you so much. Thank you.
Good morning, and thank you all for the invitation and for the chance to talk about these important matters. I'm going to make 3 points, and they're points that build on some of the observations made by Dan and by Kate and by Will. First, I'm going to expand on the wide variety of ways that lawyers currently face attack. Second, I'm going to flag some areas where the First Amendment doctrine offers protections from these attacks. And finally, I'll expand on some of the barriers to effective First Amendment remedies from these attacks. So first, the variety of ways that lawyers currently face attack for engaging in the high-value speech, petition, and association of the sort that Dan described. This morning, we've talked quite a bit, and for good reason, about the executive orders targeting certain big private sector law firms. But as Kate discussed, those are just the tip of the iceberg. And I'm going to add a few illustrations. Think, for example, of individual private sector lawyers like Mark Said, who represents government whistleblowers. Government whistleblowers, of course, are those who report government misconduct, often much to the displeasure of the government. Said's practice depends on his access to classified information, yet last spring, a presidential memorandum stripped him of that security clearance. Said has filed for an injunction, arguing, among other claims, that the executive's action violates his First Amendment rights to speech, to petition, and association by retaliating against him for his advocacy on behalf of his clients. Think, too, of public sector lawyers. New York State Attorney General Letitia James, for example, now faces federal prosecution for alleged bank fraud, charges that she argues are motivated by retaliation against her and her office's work, challenging a wide range of Trump administration actions. So too have federal government lawyers perceived to have challenged Trump or Trump administration policies. These include Jack Smith, who, when he was special counsel, brought 2 criminal cases against then-candidate Trump. Smith now faces an investigation involving allegations that his inquiries, as part of his work as special counsel, involved partisan political activity prohibited by federal law. Among the many other examples, in the last couple of weeks, after 2 veteran federal prosecutors filed a sentencing brief that described January 6 participants as, quote, a mob of rioters, the Department of Justice placed those prosecutors on leave and withdrew their brief. All of these lawyers engaged in high-value lawyering speech, petition, and association. They enforced laws against government misconduct. They challenged various government policies and practices that they believed to be unconstitutional. They represented clients unpopular with the government. And in seeking to hold public and private power accountable, this work is central to democracy and, as Dan explained, to the rule of law. Second, what are some ways that the First Amendment can protect or offer protections from these sorts of attacks? Now, as Kate explained, the 4 district court orders repudiating the executive orders targeting specific big law firms show the power of classic First Amendment doctrine, which is well equipped to handle the government's transparent retaliation against speech based on content and on viewpoint. Recall, too, that the government's unsuccessful defense of those orders included its claim that Section 1 of the orders, the section that excoriates the law firms for expression and representation of clients and causes disfavored by the Trump administration, it reflected the government's speech such that the orders were exempt from First Amendment review. And Mike, in his opening remarks, read from Section 1 of the Jenner and Block orders to give you a sense of the sorts of excoriation at issue there. But of course, the executive orders didn't just express the Trump administration's views and opinions about those law firms. The order engaged in hard law action by ordering the revocation of security clearances, the disclosure of associations, the termination of contracts, the denial of employment, and more. So Section 1 revealed the retaliatory motivation for the government's hard law actions, and thus the unconstitutionality of those actions. To be sure, in most cases where the government speech is untethered to the government's hard law action, that was not the case of these executive orders. In most cases, the government speech that is untethered to hard law action is generally exempt from free speech clause scrutiny. The government must speak in order to govern. At the same time, though, I've written about a limited but important universe of situations where the government speech can, and in my view, should be understood to violate the Constitution, and here I'll focus on the free speech clause. And I'll note that Kate has done wonderful work on presidential speech and its many uses and implications. More specifically, the government speech can violate the First Amendment when it changes its target's expression in ways that would violate the free speech clause if the government accomplished those same changes through its hard law action. And this includes the government's threats of adverse action that silence its target's speech based on content or viewpoint. Think, for example, of the Supreme Court's decision last term in National Rifle Association versus Vuillo. There, the court held that the First Amendment bars the government from threatening harm based on its target's protected expression. So under the Vuillo test, we ask whether the government engaged in conduct or speech that could reasonably be understood to convey a threat of adverse government action, and we look to see whether the government did so for an impermissible purpose, meaning in order to punish or suppress the plaintiff's speech. This principle, if taken seriously, can do a lot of work. For example, in my view, it should be applicable to threats by government officials to exclude lawyers who graduate from certain schools, to exclude them from certain public sector jobs. And recall the threats made by Ed Martin when he was interim U.S. Attorney for the District of Columbia to deny jobs and internships to anyone, quote, who is a student or affiliated with a law school or university that continues to teach and utilize DEI. In other words, threats to exclude lawyers from public employment because they are exposed to certain ideas, or threats to exclude lawyers who have associated with folks who teach or engage with those ideas, those threats exploit the government's hiring power to control and distort speech outside of the public sector workplace. And this violates the Vuillo principle. Think, too, of other Trump administration executive orders, like those related to diversity, equity, inclusion. These orders, too, include threats of enforcement action against employers, especially, but not only legal employers, that engage in what the administration calls illegal DEI. Those orders don't explain what the administration now considers to be illegal DEI. Most employment practices undertaken under that capacious term, and note that the term DEI is not a legal term of art, instead describes, it's used differently by different folks for sure, but it describes a wide range of values and perspectives and policies and practices. And most of those are clearly legal. Examples include expanding the talent pools from which applicants are recruited and ensuring that selection criteria screen for successful job performance. The DEI executive order's threat of legal action for undefined violations chill speech based on content and viewpoint. And again, under the Villot principle, the government's threats violate the First Amendment when they seek to punish or suppress speech and when they are reasonably understood to threaten adverse action against that speech. So sometimes the First Amendment gives us tools for addressing the sorts of governmental attacks on lawyers that we're discussing today. But finally, a few words about the limits of First Amendment remedies in this setting that both Kate and Will described. As a doctrinal matter, for example, current First Amendment law offers limited protection for public sector lawyers who are punished by their government employers. So even though governmental lawyers engage in the sort of high-value speech that Dan discussed, the court's public employee speech doctrine too often disregards this expression First Amendment value. More specifically, in Garcetti versus Ceballos, the court held that public employee speech pursuant to their official duties is entirely unprotected by the First Amendment. So this means that the First Amendment provides no recourse for government lawyers who are fired for doing exactly what their jobs require. Moving from doctrinal to practical barriers, in other work that he didn't discuss today, Will has exposed how, even in situations that are remediable by First Amendment doctrine, courts face complicated challenges in crafting effective remedies when the executive's willingness to comply with those remedies remains unclear and unpredictable. Will discussed another practical barrier today, revealing how the administration's threats have been effective in deterring many First Amendment challenges. No lawsuit alleging a First Amendment violation, and thus courts never get an opportunity to craft remedies. And this is the case when law firms and other targeted entities settle or refrain from bringing suit or stop the protected expression altogether. So that available constitutional remedies are so limited requires us also to consider non-constitutional remedies. Professional norms have traditionally done a great deal of work in this space. The norms of responsible and ethical practice for presidents, for Congresses, and for lawyers. We've seen how these norms have broken down in many respects in the federal branches, due at least in part to unprecedented levels of polarization and partisanship. And we've seen these norms break down for lawyers, at least in some quarters. Lawyers, of course, are among those responsible for the attacks on lawyers we're discussing today. Lawyers help draft and defend the executive orders. Lawyers help punish government lawyers for doing their jobs. As knowledge institutions and professional schools, law schools obviously have an enormous role to play in sustaining the sorts of professional norms that are now under attack. And law schools' continued dedication to these efforts are among the non-constitutional strategies available. And to that end, many thanks to Mike Paulson and to his colleagues and to the University of St. Thomas Law Journal for convening this discussion.
Thank you. That was wonderful. You saw a great demonstration of how to be succinct and comprehensive. That was tremendous. I will take the moderator's privilege here and ask a couple questions to get us started. We have plenty of time, I believe until 10:15. The first question builds off a little bit about what Professor Bode was talking about, made a statement. If we took out the retaliatory language of the executive orders, and it's also looking at the fact that we don't have anyone giving us the counter arguments from the government, and maybe there's good reason for that if this is just completely indefensible. But let's also assume that there are lawyers out there, maybe not quite as bright as this group, but we took out the retaliatory language. What arguments would they make in order to defend the executive orders, or even alter or modify the executive orders to defend some part of it, whether politically or legally speaking?
I will say, so as preparation for this, I got my most conservative research assistant to try to make these arguments to me.
This wasn't AI, was it, Will?
I hope not. Although if he found a really conservative AI, and that's where he got the arguments from, good for him. And so I'll just say, so part of what, I think it actually goes to the thing we were talking about, especially what Kate said about doctrinal boxes. I think so part of his response, and he, took a lot of this from the government's briefs, was to, if you get rid of Section 1, or if Section 1 is just government speech denouncing somebody, and as a matter of doctrine, the courts have largely not agreed with Professor Norton, and the government's allowed to denounce things. But so you put that aside. He said, if you go, section by section, security clearances. Well, the doctrine on security clearances is, in general, the government can decide what it wants to do about security clearances, and courts don't have a lot of power to second guess it. I think the government might make ripeness arguments for some of the other things. We've said these things aren't going to happen, but what's actually happened, right? And the courts often demand a concrete, is there a lawyer out there who tried to go to court and was told you can't come to court because you are Jack Smith? No. And so if you break this order into boxes and also apply the sort of ordinary principles of federal jurisdiction, at least my RA, who will soon be clerking for several of the judges who will decide these kinds of cases, says, look, it's not clear. Now, again, I assigned him to this position. I'm not even sure he believes that. But that's what I got.
Yeah, I've thought about this a little bit. I think there could still be First Amendment claims even without the sort of retaliatory argument on the basis that, at least if there's some explanation of what they're doing, that tries to explain why particular law firms were chosen, I think there would probably be overbreadth and vagueness claims. And, even if the arguments are not content-based, you might be able to make a challenge under middle-tier scrutiny. I think there's also a strong procedural due process claim. That is, to the extent that law firms are being accused of misconduct, even if it were phrased very generally and in a way that did not trigger First Amendment scrutiny, at no step at the process, either at the presidential level or at the agency levels in implementing this, is there a provision for a hearing to show that, no, you're not actually a threat to the national security or something like that. I think there are a bunch of potentially applicable claims. I've thought from the beginning that probably if they had avoided the sort of flamboyant attack that they engaged in, that security clearances were probably the most defensible. If they proceeded on an individual basis, if instead of, if they had just started opening a bunch of cases about people's security clearances and started taking them away from people who turned out to work for these law firms, I think it would be very hard to challenge, maybe impossible, because the law on challenging denial of individual security clearances, really doesn't give you much to work with. Although I think there could still be a kind of due process argument that they, never had a chance even to file a written response. But at the end of the day, I think if they had done that solo, that would have the best chance of succeeding. I think the part that would be the most difficult to uphold, putting aside, these other issues, is the sort of blacklisting where, anybody, sort of making these firms untouchable, so anybody who uses them as a client for anything is debarred from government service. It seems to me, it's hard for me to believe that the president's executive power to sort of make reasonable rules for governing the executive branch and making it work more efficiently and so on and so forth. I have a hard time thinking that implicit power goes that far.
Maybe I'll just say a couple more things. One, on security clearances, I think it's probably right, and I think that Will's point at the beginning that there is something very diabolically clever about the abuse of, not that those were your words, but that's my gloss on it.
I wish that happened.
About finding, real powers. Like, yes, we have always understood the president to have very, very broad, if not plenary power over security clearances, but it's actually an atextual. I mean, the president is always understood as the source of power to classify information, but that's not like the pardon power. It's not explicitly in the Constitution. And the power to grant, or I guess by extension to revoke security clearances, is derivative of or an extension of that power to decide what information has to be secret. But again, it's not super textual, but it is deeply ingrained in our practice that the president has this power. And I think that's right, basically. I mean, I do think, despite having been very critical of the president and the remarks I made now, and I'll keep being critical of the president, I actually really do believe in a powerful president, right? I'm not sure I totally agree that with Will's gloss on Julian as having a very, an almost non-existent conception of Article 2 and presidential power, but I definitely don't. I believe actually, and I'm a former White House lawyer, but I believe in a powerful but, constrained by law president. I don't think those two are in fundamental tension. But moving from the security clearance issue for a second, the question made me think about Trump versus Hawaii, which some of you are probably too young to really remember, but maybe, have encountered it in class. But the administration, right, did do this, it was the administration, the first Trump administration, tried doing this travel ban order and was unsuccessful in the lower courts, and then took another run at it trying to strip the obvious animus, this anti-Muslim animus that was almost on the face of the first order, not quite, but almost, and courts really saw it. And then by the time the administration did a third iteration of the order, the court did 5-4 uphold the order because it had taken on a different shape. The actual order itself was structured and written differently, and also it had been run through this interagency process that resulted in a conclusion that the court credited that certain countries were engaging in deficient vetting of their nationals before actually granting them visas to come to the United States or approving them to get U.S. granted visas. And so, it was reasonable and within the scope, particularly when we're talking about entry decisions by the president, for the president to have decided to exclude nationals of certain nations. Anyway, so I'm just trying to imagine what an internal executive branch process that tried to cleanse the unconstitutional components of these executive orders and produce something that might withstand scrutiny. I think the questions would be the same as the one the court was confronting in Trump versus Hawaii, which is, does the court sort of don blinders about what was really driving the administration in issuing these executive orders, or does it credit what the administration says? On its face, the administration would be granted a lot of deference if they said that certain, there are national security reasons the president has determined that, at least as to security clearances, maybe a few other things as well, these punishments or penalties should be imposed on law firms. I think the court was wrong to conclude as it did in Trump versus Hawaii that the order was lawful, but I think it would be even more wrong in certain respects for it to allow some version of these orders to stand. But I think it would be a very similar set of questions that the court confronted in that Hawaii case.
Great answer. Do you have any? Second question. The title of this panel is The Right of Lawyers and Law Firms to Choose Clients, but we have a lot of all the students here, I'm looking out here, this is some tremendous law students out there. Now I sound like Trump. These are tremendous law students, everything. They really are. These are fantastic law students, and they've all taken or are taking or will take professional responsibility and learned about the right to counsel, the client's right to choose counsel. So in your research, in your studies, have you seen anything about clients speaking out about these executive orders, or are they trying to stay out of this so that they themselves don't become targets? But where have you seen the client's voice or the client's role, or have they been chilled in their speech as well?
I guess I haven't, which doesn't mean it's not out there somewhere. I should have added probably earlier, the Sixth Amendment is actually another sort of unconstitutional aspect of the order, because the right of clients to choose their own criminal counsel is clearly established as a Sixth Amendment right.
Yeah, I think I have not found as much of an easy doctrinal box for this. The most vigorous sort of developed doctrinal box is the First Amendment box. Although I do think when the first order, the Covington and Burling order came out, that was sort of my initial reaction was, here, I think the core sin of Covington and Burling was that they were currently representing Jack Smith, who was worried he was being criminally investigated by the Trump administration. And so there is something about the double whammy of, we are currently thinking of prosecuting this guy who tried to prosecute us, and you're defending this guy we're thinking of prosecuting, therefore you are also punished. Does seem like it's the retaliation against somebody for the right to choose counsel to defend them against the government investigating them as like a core interest. It does make me, I guess this is one troubling thing. It's sort of related to one thing Kate said, is that I wonder if part of the reason there's less doctrine about that is in fact that kind of retaliation is more common and more tolerated quietly. I think lots of lawyers have the experience that they represent somebody and then people get mad at them about it, or government officials punish them for it, or, if you say the wrong thing to a judge in court, the next time you're in front of that judge in court, like you might get a less favorable ruling in a way that the judge will not put in an executive order, because attorney so-and-so got me overturned last time, I'm hereby giving his client an extra 2 years. But I'm sure it happens.
I should say that clients clearly, in some cases, have held the line. I know something about Perkins Coie. Their biggest clients, because it's a Seattle-based firm, are Amazon and Microsoft. And if either of those had pulled out, the law firm would have basically been sunk. And clearly, the leadership in those companies made the decision that they were not going to fold. And quietly, but nevertheless, I think very significantly.
That's an important observation. I hadn't thought of that. I liked your question very much because I think lawyers have a First Amendment right to associate with clients, and clients have a First Amendment right to associate with lawyers. But I don't think we should be terribly surprised if clients, although feeling quite harmed by these orders, lay low. If you look at the original origins of the implied First Amendment right to freedom of association, it's not in the text of the First Amendment, but it's an implied right. And those early cases where the court first recognized this right had to deal with various restrictions on the NAACP and its relationship with its clients and with its members. Those clients and members, right, the individual folks who are fighting segregation and many other injustices, were hugely vulnerable and not in a position to assert this right for themselves. So it was the NAACP that was doing the work.
All right, so we have a microphone out there. As folks in the audience are thinking about their questions, I would really like to invite the panel to think about any statements or positions or comments that their fellow panelists or the commentator, professor, has also mentioned, to either ask questions about those or follow up or add additional comments. So we have the mic going around. We have our panelists and our commentator thinking.
Professor Shaw mentioned the quite high bar for showing malicious prosecution to get a case dismissed. I'd like to have from many of the panel members a little bit more elaboration of what must be shown by, for example, James Comey to have the suit dismissed on malicious prosecution or selective prosecution grounds. And then the second question is, of the very few cases where plaintiffs have been successful, defendants, criminal defendants, in getting a case dismissed on malicious prosecution grounds or selective prosecution grounds, in how many cases has a defendant successfully recovered costs and attorney's fees against the United States government, the federal government? I'm going to leave out state malicious prosecution cases. I understand that's an extremely small number of cases. And of course, the reason I'm asking is that the President of the United States has requested some $200 million of our taxpayer money to be delivered to him to settle such claims against the Justice Department, where we're going to have Justice Department lawyers with a clear conflict of interest under Rule 1.7, making this decision supposedly and in violation of the Domestic Emoluments Clause that prohibits the President from receiving any compensation from the United States government in excess of his salary appropriated by Congress. So just a little more elaboration on those issues would be very helpful.
Thank you for that very easy question, Professor Painter.
Can I answer two parts of it briefly? So one is, at least on the second part, the sort of getting of damages from the government, there's a case, Hartman versus Moore, where the Supreme Court says, when you're not trying to get a case dismissed, but trying to actually get damages from the government under Bivens causes of action, if those still exist in 2025, at a minimum, you have to plead and prove that there was no probable cause for the underlying prosecution. That is, the law is that even if the government admits that the only reason they're prosecuting you is because they hate you and they don't like your views, as long as there was at least probable cause to think you did make a misstatement on your mortgage form or whatever else, then you can't get damages from federal officials about it, which does make you wonder about what the basis for the president's own lawsuit against the Department of Justice might be, since probably there is probable cause for all the things he's done. And I am going to take this as also a friendly amendment to maybe add that one to my list of examples. I think rewarding yourself might be a special case of rewarding your friends through an abuse of government power.
I'm going to say I think the next panel is going to have more expertise probably on that question. But I will say that we talked about this briefly last night, but the trial court yesterday, we got a ruling rejecting I think it was malicious and vindictive prosecution argument that sought to dismiss a criminal complaint brought against a New Jersey Congresswoman, LaMonica McIver, who was charged with obstructing and impeding and assaulting, I guess, a federal official at an ICE facility in Newark, New Jersey. And one of the reasons that the judge gave for, I just skimmed it yesterday, but for rejecting her argument was that she was one of a few people on site, and the other, she argued that she was singled out largely on political grounds. She was a Democratic Congresswoman, and there were two other Democratic members of Congress with her, and neither of them were singled out. So if she were singled out simply for opposing the administration, if the administration was seeking to silence critics, then it would have arrested or charged rather all of the Democratic members who were at this facility as opposed to just her. So in some ways, right, the ability to point to other critics who are not also being singled out by the government is going to be an easy way for the federal government to, evade, whether we're talking about as an affirmative defense or even potentially in some kind of civil action, a finding of a malicious or vindictive prosecution. But I think I'll just circle back to what I said earlier, which is that doctrine, I think, is going to fail us in a lot of these domains, and I think that is definitely a prime example.
I have a question building on David Granardo's question, and then a more general question. Didn't some clients abandon caving law firms and go with law firms, move over to law firms that were resisting the administration? That's just a factual question. I don't remember, but I heard some sort of news story about that. And then a question, a prediction question, sort of building on Kate Shaw's observation that the courts, and especially the Roberts Court, are reluctant to enjoin real executive powers. And I think Trump versus Hawaii is an illustration of that. What do you think they'll do if the case goes up to the Supreme Court? And will the Trump administration even appeal?
So I'll start. The first point, my understanding is yes, some clients moved away from caving law firms to litigating law firms, but also I think there has been some of the reverse. And I think one thing the schism between law firms did is emphasize the difference between litigation practice and transactional practice. And if, at a broad level, if you wanted to predict how law firms would respond to these executive orders, the law firms that make the most of their money on making deals and getting regulatory approvals quickly without ever going to court are the ones that are the most terrified of these executive orders, because no injunction is going to make the head of the FTC quickly rubber stamp a merger. And the law firms that make their bread and butter by fighting the government are the ones that are the most willing, or fighting anybody, fighting vigorously on behalf of their clients in court, are the ones for whom it's good for their brand to be fighting vigorously on behalf of the court. And if you even just look at how much of the profits per partner at a law firm come from litigation versus transactional practice, but my high school journalism teacher on the first day of journalism said, what is the most important mission of a newspaper? And we said, free press, democracy, inform the public. And she said, no, the most important mission of a newspaper is to make money. and you can never, ever forget it if you go into this business. I shouldn't mean that in a good way, but, there's something to it. I think it's telling that the Solicitor General has not gone to the Supreme Court on the docket, emergency docket, interim docket, to try to get the law firm orders stayed in the way that it has for some of the other things, and generally with a high success rate. And I think the people in the SG's office are actually pretty good about knowing how much rope they have from the Supreme Court, and they've made a judgment that if they went to the Supreme Court, at least on an emergency basis, to say these orders are obviously unlawful, they don't think they would get, or these injunctions against our orders are obviously unlawful, they don't think they would have 5 votes.
I mean, on the first, yes, I share your instinct that sort of quietly there has been movement. I know, at least with Jenner, which was maybe the biggest early, I guess I don't know, between Sussman and Jenner, but they're a big firm that has fought, and I think that it has, to a degree, redounded to their benefit. I think Will might be right. There might have been some client defections as well, but for sure there have been benefits. And I think more informally, I think that, at least among some law students who are really offended by what they've seen from the administration, there is kind of a mark on, I think Paul Weiss in particular, because it was the first and highest profile of the firms to capitulate, but some of the other capitulating firms as well. And I think those kinds of informal reputational sanctions are powerful and important. And so I think that the general count, I can't remember now, I think it's before the election, but I wrote something that talked about, or just made a brief mention of, the general counsels of in-house counsels of big firms are actually very important players here. And they can, to the kind of, sort of money talks point that Will was just making, they can, I think, actually have a significant impact in either direction, right? Either assisting or trying to thwart the administration from really effectively using this tactic. And in terms of the Supreme Court, I think I agree with Will. I think it's interesting they haven't sought emergency relief. They haven't sought stays in the courts of appeals, I think, in any of these cases either. There was a real question about whether they were even going to appeal, I think. They waited much longer, usually, they've been strategic, for sure, but I think it was conspicuously slow, the first notice of appeal they filed after losing one of these law firm cases, and they are now appealing them. But I have no inside information, but I feel like that delay reflected some genuine internal debate and deliberation, and whether that was about, to the exchange we were having before, whether to go back to the drawing board and try to craft something they thought would have a better chance of surviving, or maybe just to let it lie. They were winning in all the cases they did take up, and maybe people wouldn't notice if they just let these things die quietly. But obviously, the voices saying fight won out. But I do think that fight on a slower track is significant. And I think at the end of the day, I think this is going to, I could see the Supreme Court deciding to notch a win here, a win for constraints on executive power that conveniently is also a win for their own sort of public kind of stature and kind of perceptions of judicial independence, and a win for the Guild of the Lawyer, which of course they're all members of, and many of them obviously alums of big law firms. And so I think that the chances of these orders being struck down at the Supreme Court are actually pretty high. And I don't predict that often with anything this president does in front of the Supreme Court.
Yeah, I agree with Kate. I think given Section 1 of the orders, but also given the content of some of the specific provisions, I think it would be difficult for the court to uphold these executive orders. I had one thought about Trump versus Hawaii, which I'll just throw in there. On the one hand, it's somewhat reminiscent, and clearly the idea of going back and doing it again. But one very significant difference is that there was a statute in Trump versus Hawaii, which the Supreme Court had previously construed as really giving the executive branch, the president, almost unbounded authority. So we're really in to the extent that this still has significance, we're in a steel seizure category 1 case where the president is acting with strong support from Congress. And that's not true of these executive orders, and except to the extent, I don't know if there is any statutory basis for security clearances, so maybe there, but I think otherwise, at the best you could say is that there's no grant or prohibition.
I would add to that, I think it's important to note, as law students who are about to start practicing, well, what can I do? Where do my principles, where do I stand? One of our graduates, a very prominent graduate that we have, she actually left her law firm because her law firm did not speak out about these executive orders, not even that they were a target of it and that they didn't fight it, as just simply that they did not speak out against these executive orders on behalf of other law firms who were named in those. So there is something that you can do. Now, she had the ability to move, and she had the opportunity to move, so that's something that you'd have to think about. But there is something that you can do in certain situations.
Please give a round of applause for our first panel.
I don't know what to do about that.
And we will take a brief 15-minute break and reconvene at 10:30 for the second panel. Thank you.
All right. Hello, everybody. My name is Amy Wildermuth. We're going to get started with our second panel. So I'm going to let everybody get a chance to get your seats while I introduce folks. So again, this panel, I'm going to give you the official long title. Here we go. The Right to Counsel, Lawyers' Professional Independence, and the Practical Consequences of the Trump Executive Orders. And we have a fantastic panel with us. I am going to just briefly introduce everyone, and we're going to get started. Our first speaker is Richard Painter, who is the S. Walter Ritchie Professor of Corporate Law at the University of Minnesota. Following Richard, we'll have Judith Miller, Clinical Professor of Law in the University of Chicago Law School's Federal Criminal Justice Center. And then last but never least, Rachel Moran, who is a professor here, and Robbins Kaplan, Director of Clinical Education. So I'm going to hand it over to Richard now.
Well, with the sun coming into my eyes here, I'm going to try the podium so it's a little better. We don't have this issue at the University of Minnesota Law School, where it's quite dark. Although we have a nice atrium with a portrait of Walter Mondale there. And I want to express my gratitude for being invited back to University of St. Thomas Law School. Last time I was speaking at a podium here was 20 years ago. I was reading the commission from the President of the United States for Judge Pat Schultz for the federal district judgeship here in the District of Minnesota. The White House, they knew when I was the chief White House ethics lawyer that I was going to be coming here to Minnesota. I reminded them, by the way, many times that I had waiting for me a tenured position at the University of Minnesota, because every time I ran into difficulties with my ethics advice and whether it would be followed, and people telling me to get with the program, I said, well, no, I've got another job waiting for me out in Minnesota. But they did send me out to read the commission for Judge Schultz, and we had Justice Scalia and other luminaries here. I had an opportunity to speak in this beautiful atrium. It was in the afternoon, so the sun wasn't coming into my eyes. Tom Mengler, the former dean of this law school, was a good friend of mine from the University of Illinois, Urbana-Champaign. I grew up in Urbana-Champaign, knew him ever since the 1980s. And I'm so very impressed with the phenomenal success of this law school. And one of the most important components of the success of this law school has been the emphasis on ethics and values. People being willing on the faculty and among the student body here to talk about moral values in the legal profession. And what I want to discuss today is the role of lawyers in government when confronted with the threat of totalitarianism. I'll use as polar and different examples. Sir Thomas More, the statue here, who stood up to King Henry VIII and refused to take an oath of loyalty to the king that was so complete that it conflicted with his fundamental moral principles. Thomas More was willing, as Lord Chancellor
to swear allegiance to the king in all things temporal. He was not standing up for democracy, no, but there were limits to how far authoritarianism could go. And when the king said that he was the head of the church, Thomas More said, no, I cannot swear allegiance to you, the king, as the head of the church. My principles are different, and I'm willing to die for my principles, and that he did. Executed for standing up to a king who went too far. A Lord Chancellor of England willing to pay with his life, standing up for the rule of law as he saw it. At the other end of the spectrum, we find a German legal philosopher of the 1920s named Carl Schmitt. And during the Weimar Republic, which had a constitution, and a reasonably well-drafted constitution that was designed to protect against authoritarian rule, but also assure a functioning representative democracy, Carl Schmitt developed and wrote about a number of abstract theories about the rule of law, and I'll mention three of them. First was the idea that law is simply politics. Now, we all know that in a representative democracy, of course, politics will influence the content of law, statutes, and the appointment of judges and justices. But that is one thing to acknowledge that, but it is quite another to say that law is nothing but politics. And that is essentially what Carl Schmitt said in his famous essay, The Concept of the Political, published, I believe, in 1932. In a representative democracy, in the last year of a representative democracy, but nonetheless speaking out for the proposition that there is no absolute truth in law other than what those who are politically powerful would seek to impose on others. Second, the idea that politics is about friend versus enemy, that the friend versus enemy distinction is critically important to politics and therefore to law, that how you treat an enemy should be polar opposite to how you treat a friend under the law. And third, the idea of the executive as the exception. And of course, representative democracies have struggled with this issue for many years. How much power shall be entrusted to the executive as opposed to the legislature and to the judiciary? This is a question that has been debated going back to Magna Carta in England. But Carl Schmitt's theory was the executive must have the power to make the exception to the law, because the executive, in the Weimar Constitution, the executive being the president of Germany, who then would appoint a chancellor, who would have the support of the parliament, that the executive speaks for the entire country, because the executive is elected by the entire country, the executive speaks for the people, for the will of the people, and that therefore the statutes passed by the legislature and the rules articulated by the courts and the judiciary should be subservient to the executive. The executive should have the power to make the exception to the law. And the fourth point I want to make about Carl Schmitt is that he was not just a theoretician of law, but he worked to put these ideas into practice while Germany was a democracy. In 1932, there was a case called Reich versus Prussia that involved facts disturbingly similar to some of the facts we see being pled before the United States Supreme Court in Illinois versus Trump, and the case brought by the governor of California, and other litigation, of course, arising out of the incursion of federal troops into Portland, Oregon. And keep in mind, this was at a time when, yes, Germany was a representative democracy. The problem was civil disorder in the state of Prussia. Riots between communists who surely wanted to violently overthrow the government of Germany, this is true, and National Socialists and right-wing extremists who had a similar vision of establishing authoritarian rule from the opposite end of the political spectrum. And the government of Prussia made it clear that they were going to do what they could to establish civil order, but they did not need the federal troops. The president of Germany, 85-year-old Paul von Hindenburg, and his chancellor, von Papen, decided, well, no, we do need to send in the federal troops. And they invoked Article 48 of the Constitution of the Weimar Republic, which allowed in very limited circumstances the federal government to establish order within one of the individual states of the Weimar Republic. In very limited circumstances, and a provision of the Constitution that, when read in conjunction with the implementing legislation of the Parliament, allowed the Parliament ultimately to veto such a move to send troops into a state to establish rule of law in the view of the President and the Chancellor. Carl Schmitt was counselor, attorney for the federal government. And that was the famous case of Reich versus Prussia. And he figured out a loophole in the constitutional statutory framework. A loophole that, if allowed, if the legislature, the Reichstag, was not in session, considerably more power to the President and the Chancellor to proceed with the emergency deployment of federal troops into Prussia against the will of the government of Prussia. Reich versus Prussia went up to the German Supreme Court, which came down with a very both sides type of opinion. It said, well, there are limits to this power under Article 40, but temporarily we were going to allow this. The upshot was, under Reich versus Prussia, that the Supreme Court of Germany, with quite a lot of prodding from attorney Carl Schmitt on behalf of the federal government, allowed the deployment of the troops. That was, of course, not satisfactory to the German government. The chancellor was replaced the next January with a new chancellor, Adolf Hitler, who then took advantage of that precedent. Only months later to deploy troops throughout the entire country and establish a dictatorship in a matter of months. The reason I point this out is to engage everyone here, and I hope throughout our country, in a conversation about what is the role of the government lawyer in representing the government, in particularly the executive branch of the government, when there is overreach of executive power. Is the role of the government lawyer to exploit the loopholes in the constitutional and statutory framework, as Carl Schmitt did in the Reich versus Prussia case in the last year of the Weimar Republic? Or is the role of the government lawyer to assess what the best interpretation of the law is and insist that that be the interpretation that is followed, or the lawyer will resign and let the client know that? I compare in a recent article I wrote in the Case Western Law Review the role of the government lawyer to the private sector lawyer. There are plenty of private sector lawyers who will figure out ways to manipulate your way around the statutes and regulations. I use tax as an example. Tax avoidance. Where did that phrase come from, avoidance? What does that mean? Well, tax evasion is a criminal. You go to jail for tax evasion. Tax avoidance? Oh no, you don't go to jail, but that's just finding a legal loophole. For example, you really moved to Minnesota, from Minnesota to Florida to avoid our sky-high income taxes, and you actually stay down there 6 months and a day. Okay, that's tax avoidance. Tax evasion is pretending you live in Florida when you don't. And, you know, you go to jail for that. And this book was written by a bunch of London economists back in 1979 called Tax Evasion, and all the strategies that can be used to get around the taxes. You know, in my courses on ethics or business lawyers, I warn against this because it can get you in a lot of trouble, particularly if the avoisin becomes evasion. So avoisin is halfway between the evasion, illegal, and avoidance, sort of legal. You're playing around in that gray zone. And the private sector, you can get a lot of trouble there when it doesn't work and it blows up in your face, and yet you get a lot of pressure from the client. Okay, well, that's a conversation we have with the business lawyers and the tax lawyers. When you are a lawyer for the government, who is your client? Is your client the President of the United States because the President represents the will of the people? Do we really want to go back to Carl Schmitt and his idea that the President represents the will of the people? I don't think so. The client is the United States. Under the Supremacy Clause of the Constitution, the statutes, the treaties, as I reminded some people in the Bush administration, that includes the Convention Against Torture, the statutes, the Constitution, and the treaties of the United States are the supreme law of the land. So now, who is your client? Does not your client embody, in some respects at least, the law itself? Is not your duty to your client as a government lawyer, whether in the Justice Department or in the White House or in an agency, to the truthful, accurate interpretation of the law, not the far-fetched argument that could be made, and you could always make a far-fetched argument, just as you can always try to deploy an innovative tax loophole and take your risks. And I get back to the torture memos. They were classified, so the White House ethics lawyer doesn't get to read them except for in the New York Times. And the twisting of the law, in many respects that I do not have time to go into here. Twisting of the law, distortion of the law, arguments about self-defense and necessity, and that somehow Article 2 of the Constitution takes priority over, supersedes the statutes and the treaties entered into by the United States. And we've seen these ideas come back again and again. Will government lawyers in the Office of Legal Counsel, in the White House, and in the agencies stretch the law to its utmost in support of executive power? Or will they adhere to their obligation to their client, the United States of America, and to the law, the Constitution, the statutes, and the treaties, by articulating the best interpretation of the law, what the law really means, whether the decision is to issue an executive order against Covington and Burling or Perkins Coie, or whether the decision is to deploy federal troops to Chicago or Los Angeles or Portland, Oregon, or I hope not someday to Minneapolis, Minnesota. Is the job of the government lawyer not loyalty to the person, the head of state, but loyalty to the law itself? Does the modern executive branch lawyer want to be Sir Thomas More or Carl Schmitt? Thank you.
Also stand up. I'm sorry to do this to everyone, but I'm actually a practicing lawyer, and so I have a PowerPoint. So you can tell the defense crisis is a government crisis. let me just ask a show of hands. Who knows, if I say the defense crisis, who knows what the heck I'm talking about? It's okay if no one raises your hand. Does someone, okay, there's like an iffy. All right, fair enough. That's where I thought we would be. So there is a crisis in federal criminal defense. I'm gonna tell you about it in a second. And then I think too, I was gonna say it's worse than you think, but I think it's gonna be, you don't think it yet. So, but like much of what has happened in sort of our modern political legal regime, there's a crisis that I think exploits and expands on pre-existing vulnerabilities. It's not something that just poofed into existence in 2025. This is something that has been building for quite a long time. And then the second kind of point that I want to make, because there's a way in which the defense crisis is somewhat orthogonal to some of the issues with the executive orders and the high-profile criminal defense cases that folks have been talking about so far, is that the defense crisis, which I know asterisk, right, it's also a government crisis. I could call it a judiciary crisis, but I'm not even really sure I want to limit it to that. And it's not just about the weaponization cases, sort of Comey, Letitia James, those cases. The problem, I think, is also extends to the sort of normal criminal cases, immigration, guns, drugs. That's more or less the entirety of the federal criminal docket. So I'm going to back up, starting at the basics. There is a right to appointed counsel. It's in both the federal criminal system and in the state criminal system. This is, even if you don't know about the crisis, I'm confident you know about this so far. And in 1964, Congress passed what is called the Criminal Justice Act. Now this statute set up a nationwide federal criminal defense system. It's interesting because these are attorneys who represent clients, and yet the criminal justice attorneys or the federal criminal justice system is actually housed in the judiciary. So it's part of the judicial branch. It's funded through the judicial branch. It's a little strange, but there's lots of writing about this, but it's kind of an interesting thing. What the Criminal Justice Act did is it didn't just set up a system of federal criminal defense. It also set up a system of paying for federal criminal defense. That was a big deal because there have been attorneys who have been appointed by judges for a long time to defend indigent criminal defendants, or in some cases in civil cases. The idea of appointing attorneys to represent people in court has long been part of the responsibility, or serving in those appointed capacities has long been part of all of our responsibilities as members of the bar. But by the mid-1960s, the criminal justice system, or the criminal system, was changing, and the previous sort of appointment system was no longer working for a variety of different reasons. And so Congress enacted this statute to pay for federal criminal defense attorneys, federal public defenders. It was not a lot of money, not back then. The money has increased now. It's still, honestly, it is not a lot of money, but it is enough that a public interest attorney can make, a meaningful amount of money to contribute to the support of themselves and their family. It's a career, it's a livelihood that you can make a living in. And I'm maybe a little biased, but it's good work. You should all go apply to be federal defenders and CJA attorneys. So over the next few years, what happened is that the judiciary worked with private attorneys to build up a system of federal public defender offices, and these are what I would call, they're federal defender offices and community defender offices are what we call them now, and also what's called federal defender panels. The panels are private attorneys, so they have a private practice of their own, and they take appointed cases. We usually call these panel attorneys or CJA attorneys. How this is set up in different districts varies a little bit, but that's sort of in broad strokes what the system looks like. And I should, just in all candor, I formerly worked in a community defender office, one of the first in the country in San Diego, and now I'm a member of the Criminal Justice Act panel in the Northern District of Illinois, where students and I work together and we take appointed cases, and I I, with student participation, currently represent folks under the Criminal Justice Act. So, a chart, right? The rise of the federal defender system really parallels the rise of the federal criminal system as a whole. You know, this chart, I kind of mashed together two different charts from the judiciary. Maybe you can't read it, so if you can't see it, that's fine. I'm just going to tell you the important parts. Late 19th century, there just is not a lot of federal criminal law. There's not a lot of administrative states. There's not a lot of federal criminal law. There are not a lot of federal crimes. It's just basically crime is a state matter. It's not a federal matter at all. There's this enormous spike in federal prosecutions that you can see here. This chart is sort of essentially the total number of people in the federal charged in the federal criminal system, I believe. And the chart is, you know, this, in prohibition, essentially, there's this huge spike in federal criminal prosecutions relating to prohibition. Prohibition ends, those prosecutions end, now we're in the New Deal. And the thing is, the numbers don't return to where they were because now we've sort of created the administrative state, and along with the sort of the New Deal state, there is a sort of the beginning of kind of the federal criminal system that we know today. More or less right after the Criminal Justice Act was expanded or was enacted, that's when we see sort of the very first spike in federal criminal cases. And then there's sort of essentially a steady rise through the present. It's hard to imagine sometimes that things were different than the way they are today. But before the sort of the war on drugs, there just were many fewer criminal cases. Today, the federal criminal docket, so this chart, by the way, goes only through 2015, but I'll just tell you the numbers go up after that. There was a sort of a dip in the mid-2010s, and then things go up afterwards. You can actually measure the total number of criminal cases differently. It's sort of interesting, how do you measure these things? But however you measure it, there's sort of this giant expansion in federal criminal law, and it parallels the sort of the expansion of the guns, drugs, and immigration prosecutions and the federal criminal justice, sort of the existence of federal defenders. The bottom line, I think, is that however you measure it or however you want to look at it, and for good or for ill, the federal criminal system today requires federal criminal defense attorneys, largely federal public defenders. That's as a legal matter under the Sixth Amendment, but also kind of just a practical matter. There are a lot of cases, and they are complicated cases. It's not something where you can just take your general knowledge of how law works and kind of walk into a courtroom and kind of, you know, do it on the fly. We now require attorneys to do an adequate job. Not even really a good job, just an adequate job. But even just adequate means you've got to meet with the client, like more than once, right? You've got to actually meet and talk with a client. You have to interview witnesses if there are witnesses. If the case goes to trial, it's going to require multiple days, quite possibly multiple weeks. If the case goes to sentencing, which is the most likely outcome, I mean, I don't know if any of you have taken sentencing. It is arcane and Byzantine and complex and almost a mini trial in itself in the federal criminal system. It's just not something where you can rely on a one-off members of the bar who don't practice in the area, kind of taking the cases one at a time. And I think my experience is that when I talk to judges, and that includes judges who might think of themselves as sort of not necessarily a friend to the defense, they recognize this as well. The system relies on federal defenders, which is a complex, for good or for ill. So of the cases in the federal criminal system, 90% of them are appointed. That little blue bar at the end is 10%. I couldn't write it there in a way you could all see. So just, 90 plus 10 is 100. Of the 90% of the appointed cases, 40% of those are panel cases, and 60% go to federal defender or community defender offices. That's a nationwide average. So in some districts, the panel is really large. The federal defender office is small. In some districts, the federal defender takes all of the cases except for the conflicts. So the panel is very tiny and the federal defender is large. whatever. This is how it, this is the rough breakdown. So the other thing to know is that the CJAs are largely small firms or solos. They're the opposite of the kind of the Paul Weisses of the world. Now, as it happens, there actually are sometimes CJA attorneys in large firms who take these cases and they handle them pro bono largely, but most of the cases, 85% of the CJA cases, are small firms or solo practitioners. All right, so why is all of this relevant? Where is the crisis? This is all just background so far. So here is the crisis this year. The CJA attorneys were last paid in early July. The federal defenders were last paid on October 1. Now, you might have read there was just a federal funding bill that was just passed, which is terrific. When I made this slide, there was no bill passed, but it does not actually solve the problem, and I'll explain why in a minute. But the part of the reason why the crisis was especially acute for CJA attorneys is not just that they did not get paid since July 2025, but also because as small firm lawyers or solo practitioners, they have no other sources of income. It's not a firm model where there are multiple attorneys with lots of different income streams, and if one income stream fails, somebody else can kind of take up the burden. That's not what happened. Instead, it's just one person who is simply not getting paid for months and months and months at a time. I can, give an example. I talked to a friend of mine who's making a living as a panel attorney in the Southern District of California, where I used to practice. This friend of mine works primarily as a panel attorney, so has very few private cases, and essentially they're living off of a home equity loan. And even when the funding is restored, certainly the interest is not going to be restored. But wait, there's more. That is bad enough, but if that were it in isolation, but that is not it. So I'm gonna go back to 2013. This looms large in my memory, but perhaps not in yours. There was sequestration, which was a complex budget process that sequestered or took away approximately 10% of the federal defense budget. The result of this was 20 days of furloughs. Approximately 500 attorneys and staff were laid off. A third of those 500 people were attorneys. There were CJA rate cuts, so the amount of money per hour that the appointed panel attorneys would get, that the rate cuts lasted 6 months. There were weeks of suspended payments. Ultimately, the money was restored, although of course the attorneys had to kind of carry the government for a while. The damage was done by then. It took years to recover. And I guess I would just say anecdotally, I think the recovery is still in process. In 2023, for example, I spoke with the acting executive director in the Middle District of Georgia. They'd closed a branch during sequestration. 10 years later, they were hoping to reopen the branch office, just as office space, not to hire an attorney who worked there, but so that when their attorneys did their 4-hour round-trip drive to see clients and do appearances at that branch, they would have a place to work other than their car. So that's 10 years after sequestration. Let's see. We have COVID, 2023, there's for very complicated reasons, there's essentially a reduced appropriation. Reduced money goes to the federal defender from Congress, so the total amount is the same, but the amount that Congress appropriates is lower. And then in 2024 and 2025, Congress appropriates the same amount of lowered money for the judiciary, for the defenders in the judiciary. As a result, basically, the defenders keep getting squeezed further and further. It's essentially do more work with less money. There's been a hiring freeze for the federal defender offices for 18 of the last 24 months. There's the payment delay since July. This is not the first payment delay that the panel has had to deal with. And you can see these are just some headlines. I stopped at 4. I could have filled this slide with sort of headlines talking about or characterizing what's going on as a federal defense crisis, and it certainly is a federal defense crisis. I don't want to minimize that. For example, the Central District of California, which we'll return to in a second, reports that they used to have 86 panel attorneys and they're down to 20 now because attorneys are not willing to not be paid for their work, which, I mean, is pretty obvious. I would say small offices around the country report paying for staff with personal funds and so going into debt. Multiple attorneys report that the court owes them over $100,000 for their work. Others are living off of credit cards, home equity loans. Even the sort of routine cases, the courts owe attorneys sort of in the 5 figures, essentially. I don't want to whine about the poor little rich girls, right? We're all attorneys have jobs. We could go do something else, at least in theory, although it's hard. But of course, all of these issues are felt by the clients even more acutely than the attorneys. Extensive delays, people can't pay for experts. Of course, pretrial custody is much worse than prison. There's more uncertainty. Essentially, the pretrial system becomes even more punishing than it already is. So, all of this is bad. There's a lot of bad things in the world today. Why am I talking about this here at this panel? What does this have to do with the current political moment? All right. Here is what I want to show you. So these cases, the blue cases, those are the weaponization cases. Those are the cases that the first panel talked about and that are in the headlines. Those are the sexy cases. All of those people can pay for their own attorneys. Those people are not affected at all. Well, maybe except to the degree that judges are affected, and so judges are sort of slowing down cases. They're not affected by an access to counsel problem. It's the regular law people who are affected, really devastated by the funding crisis, which is its own constitutional crisis. And you know, I've been thinking about this. I'm not sure the right way to put this. I've been sort of thinking through this as I was getting here. So, you know, maybe I'll think of a different way of putting this later. But, you know, a lot of what the executive branch does, we don't have to do it. Congress could, as Kate Shaw pointed out, not direct the executive branch to do USAID. I mean, there are hundreds of thousands or millions of people who will lose their lives if we don't do it, but it is, in fact, not constitutionally mandated. Criminal defense attorneys are constitutionally mandated, at least for now, to the degree the government wants to continue prosecuting cases. Of course, prosecutions are not mandated. There's also, of course, the practical matter of the role of criminal defense attorneys. So I think there's a question, or there's this thought of, there's a sense in which the fact that public defenders are funded is always, in some sense, has always been a miracle. The existence of the Criminal Justice Act is astonishing. I'm sure you know politicians are generally not sympathetic to criminals. You know, politicians love to spend more money to be tough on crime, but appointing attorneys to defend criminals is not a popular position. You know, it really is astonishing that the Criminal Justice Act passed in the first place and has been funded more or less, you know, okay, kludging along over time until approximately the present day. You know, I was reading an article about this. It was sort of interesting that part of what happened, part of the story was sort of the judiciary starting to appoint elite lawyers to represent criminal defendants for free. And then you might imagine they did not enjoy that. And you know, there were also a lot of other issues going on in the country at the time, of course, but there was a sense that the bar and the judiciary needed public defenders in order to continue its own operation. This was a rule of law issue or a bar issue leading to the passage of the Criminal Justice Act, at least in part. And you know, today I kind of want to give credit where credit is due and say that there was this stopgap funding measure that was passed, and the funding measure that was passed does contain an anomaly that essentially pays the panel attorneys for their work that they've been doing since July 2025. So it's solved for the past, it's not solved for the future. And you know, the funding measure that was passed does not solve the problem for the future either, the problem of insufficient attorneys to take cases for the regular rule of law and the regular criminal system. So what's been sort of fascinating is that it's not just me who sees this as a systemic problem, it's also prosecutors who see this as a problem. And I want to show you this really astonishing memorandum. I'm going to summarize it because it's sunny. I don't even know if you can see this. This is from the Central District of California, United States Attorney's Office. It was made public at least on October the 27th, where they essentially, between the lines, they advocate for the judiciary to appoint counsel without pay to represent clients at the initial appearance and detention hearing, that's essentially the bond hearing in federal court. Not just on a one-off basis, but to do that systematically, that's the solution to the absence of attorneys. Obviously, I think that's wrong and a terrible idea. Probably illegal, but what they do is they approach this in the kind of one-off way. The attorneys have an obligation to take cases, judges have the authority to appoint an attorney to represent a client in a case, and approached in this one-off way, there's no problem with doing this. They sort of admit that this is their systematic approach. I don't know what's going to happen next. This is unheard of. This is totally sort of bonkers. Stopping the funding creates uncertainty, delay, kind of chaos in the normal law. That destabilization is not just the weaponization cases, it's the normal cases. And it's so different from other areas of law where, that in order for the administration to get the convictions that it wants, it has to go through other people. It has to go through defense attorneys, it has to go through judges. And I think you see that in this memo. No one in the administration is saying that scientists should continue to run their experiments without being paid to do so. They say they should stop doing the experiments. Here, the claim is that people should be doing the work and just not being paid. It is really remarkable. And I take this in a way as a sign that judges and defense attorneys, at least, are in some ways standing up, that they are saying, you have to go through us. Otherwise, there would be no need to have them come to court. And so I just hope that judges and defense attorneys, and to the degree Congress is involved with funding the defense attorneys and even the executive branch in signing the funding bills, continue to do so, because this is not exactly just a Trump problem. This is an all branches problem, although of course the executive plays its role, that are going to be involved with, I hate to put the stakes like this, but sort of saving the federal criminal system and the rule of law within it. Thank you.
All right. Hi, everyone. I have been sitting in the sunny atrium on and off for 7 years, and my eyes have just developed scales over them. So I'm going to stay right here, wearing my black suit, soaking up enough body heat to get me through the winter. My presentation today is going to focus on one of the downstream effects, among many, of the Trump executive orders targeting lawyers. And that's specifically interference with law school clinics and in their independence in selecting cases and clients. So the executive orders do not mention explicitly law school clinics, but I'm taking the position today that they've enabled other political efforts from allies of the administration to criticize, intimidate, and bully law school clinics and even clinic students. and potentially other nonprofits as well, representing low-income people and/or politically controversial causes. Because many of the clients that law school clinics represent are people who cannot afford private counsel, these orders also have downstream effects on the right to counsel. So I'm going to give you 4 to start off with, just that have happened in 2025. There's at least 4 pretty high-profile political efforts by either the administration or friends of the administration to interfere with law school clinics. And I'll start with the first one chronologically, which was not an explicit, this is the only one that was not an explicit attack on clinics, but it implicated them. So one of the executive orders we haven't mentioned yet today came in February 2025, and it prohibited, among other things, lawyers from providing legal services to or for the benefit of the International Criminal Court. And that was because of the ICC's investigation into the possibility of war crimes committed by Israel and Palestine. The order threatened criminal and civil penalties against those who provided services to the ICC. Again, it did not explicitly mention clinics. It's not even necessarily targeted at lawyers, but it certainly encompasses them in the broad language about criminal and civil penalties to those who provide services. Some clinics were implicated because they, like international human rights clinics, because they had provided and do provide services to the ICC. So one of them is City University of New York Law School Human Rights Clinic. The clinic's work includes submitting amicus briefs and providing trainings to the ICC's Office of the Prosecutor. The clinic director in that case herself personally filed a lawsuit seeking a permanent injunction against enforcement of the executive order. And as of end of July, a federal district court had granted the injunction, did grant the injunction, finding that the executive order, as we talked about in the first session of the day, unconstitutionally regulated protected speech based on its content, which was advice to the ICC. So that's the example that specifically involves an executive order, although it does not explicitly target clinics. The other 3 examples do, but they're not executive orders. This is where I'm talking about what I perceive as downstream effects of the orders. So in March 2025, congressional committee, specifically the House Committee on Education and the Workforce, which oversees the Department of Education, issued a written, it was called a request for disclosure, although it sounded more like a demand, but they called it a request for disclosure to Northwestern University, seeking budget data, donor information, policies, and personnel data from the law school's Community Justice and Civil Rights Clinic and its 19 other clinics. The Community Justice and Civil Rights Clinic had gotten the attention of the House Education Committee because it had filed a lawsuit on behalf of 40 organizers of a protest that involved a blockade of highway traffic. One of the organizers had engaged in explicitly anti-Semitic language. And I want to say that because the language was, I know there's a lot of debate about what is anti-Semitic, but one of the protesters, I would say, unquestionably did engage in anti-Semitic speech, and she was one of the 40 clients that the Northwestern Clinic had agreed to represent en masse. The committee letter identified the clinic professor by name, identified that single protester by name, and then noted that the committee found it troubling that Northwestern is supporting protesters generally. The letter also critiqued the Northwestern clinics more broadly, not just that particular clinic, as, quote, engaged in left-wing political activism. And it cited a class called movement lawyering that allows students to work with community organizers. Specific aspects of that class that was part of the clinic that the committee called out in its demand letter included work on, quote, creating a more just Chicago, and getting involved in legal issues such as, quote, a court order aimed at transforming the Chicago Police Department. So specifically, that clinic was involved in helping to enforce a consent decree, much like the one in Minneapolis, between the Minneapolis Department of Human Rights and the Minneapolis Police Department to change policing in that instance in Chicago. The committee sought course materials for the professors, performance reviews and student evaluations for the Community Justice and Civil Rights Clinic, a detailed budget for all 20 clinics, internal policies about how the clinics engage in client selection, and quite a bit more information. The professor whose performance reviews were sought sued for injunctive and declaratory relief along with one other clinic professor, both untenured at Northwestern. They filed lawsuits, and in response, the House committee withdrew its demand before any major litigation took place. However, they have continued to place less formal pressure on Northwestern University, and from my understanding, the clinics are still engaged in a lot of back and forth with the university about things like case selection now. The third example I'll mention happened at Tulane in their environmental law clinic. So Tulane Law School was involved in a project where they were expecting, they're basically expanding their downtown buildings, and we're expecting significant funding from the state of Louisiana. One of the professors, actually I think more like not a professor, a staff scientist and director of community engagement in the environmental law clinic, but a faculty member. She was involved in research that highlighted racial disparities in hiring practices at Louisiana petrochemical facilities. She published her research and got a lot of attention. In response, Louisiana's governor, Republican Jeff Landry, threatened to veto any state funding for Tulane's downtown expansion unless the university cut off the work of the environmental law clinic. The law school dean, and I've seen copies of these emails, the dean sent an email to the faculty noting that elected officials and major donors have cited the clinic as an impediment to them lending their financial support to the university. And the dean then implemented a new communication policy for the entire clinic and all professors that, quote, effective immediately, all external communication not related to the representation of clients must be pre-approved by me. Such communications include press releases, interviews, videos, social media postings, and more. In response, that the staff member or staff scientist who was had published the report that drew the attention, resigned in protest. And the last example I'll give goes back to CUNY law, but a different example. A tenured professor at CUNY law who teaches an immigration clinic, his name's Ramzi Qasim, their clinic has been representing Mahmoud Khalil, who you might recognize that name, is the lawful permanent resident who the Trump administration detained for multiple months because of pro-Palestine activism. During another same committee, House Committee on Education, the same committee that had sent the request letter to Northwestern, one of the representatives, whose name is Elise Stefanik, and she's in New York, stated publicly that the professor should be disciplined or fired for the act of representing Mr. Khalil. So that's not ongoing litigation, that's just a public statement about attempting to interfere with CUNY's choice. So these are the examples from the current year. They're not all on behalf of the Trump administration, but these are all examples of statements by people who identify themselves as friend of the administration. I do want to say these are not brand new concerns. 2025 is not the first time that politicians have attempted to express their views or otherwise interfere in clinic selection. Just last year, actually, the then dean, no longer dean of the University of Georgia, ordered the law school's First Amendment clinic to withdraw from a public records lawsuit it had filed against the Atlanta Police Foundation. You may have heard of the Cop City case, but that involves a huge effort by activists in Atlanta to prevent the city from expending enormous amounts of funding on building a massive new police training center. So the clinic sued the Atlanta Police Foundation, or sought records from the Atlanta Police Foundation, and the Police Foundation was represented by an adjunct professor at the law school who was also a former Georgia Supreme Court justice, and the dean told the clinic, shut it down. The first reported interference effort at political interference with clinicians goes all the way back to 1968. Two untenured clinic professors at University of Mississippi had partnered with a local organization to file a school desegregation lawsuit. The lawsuit was deeply unpopular among politicians in Mississippi, and the school responded by saying that they would only continue the professor's employment at University of Mississippi law if they agreed not to work with that local partner and to withdraw from the desegregation lawsuit. So these aren't brand new, but I do think, so the question might arise, how does this relate to the Trump executive orders? I'm taking the position that the tenor of the attacks between many of the things we're hearing today and the language used in the executive orders is quite similar. And I'll give you an example. In the House Committee's letter to Northwestern, where they are disparaging the clinics for engaging in so-called left-wing causes, they say they criticize Northwestern for allowing students to engage in progressive left political advocacy. The executive order targeting Jenner and Block, which came out around the same time, criticizes Jenner for engaging in, quote, partisan representation to achieve political ends, and calls out specific types of partisan prosecution that they deem left-wing, such as attorney at Jenner who was engaged in the Robert Mueller's investigation into the previous Trump administration. So they're calling out lawyers they dislike by name. They're calling out professors they have a problem with by name. Even people who are not terribly well known on the national stage. We're not talking about really high profile people, but the House Committee, for example, identified the Northwestern professor by name. And then they're punishing law firms or clinics, or attempting to, for engaging in administration that they deem politically unacceptable. And last, I'll say, how does this implicate the right to counsel? There are two professors at WashU Law School, Bob Kuhn and Peter Joy. They've recently published an ebook called An Anthology of Political Interference in Law School Clinics. They are the experts on this topic, much more so than me. But they note that interference with clinic case selection almost invariably seeks to, quote, subvert the legal process by preventing clinics from representing their clients rather than addressing the legal merits of the clinic's clients' claims. In other words, the strategy here is not to say, let's address the substance of your claims and win on the merits. The strategy is to say, you shouldn't be litigating these cases. You shouldn't be representing these clients. And that's true in every example I gave. Professors Kuhn and Joy give a lot more examples. And then they say it's important to recognize interference in law clinic representation for what it really is, a strategy designed to circumvent adjudicating legal disputes on the merits and instead deny legal representation and access to the legal system for those with limited economic and political power.
All right, thank you so much to our panelists. Now I think we're going to take questions, and I believe we have Quinn's going to run around with a mic, right? Okay, so do we have any questions to start us off? Oh, we got one in the front.
Hey, thanks for all coming here and for sharing your presentations. It's very insightful and very much appreciate your time. I think this question specifically for Professor Painter, kind of building out of your commentary and how if you have a government lawyer who should not just capitulate and say, okay, let's do whatever maybe the administration or the executive wants to do. And the big point of that was saying, okay, let's go for this single best interpretation. And I guess going beyond that, what my question would be is, well, what is that single best interpretation? Because wouldn't that kind of depend on the individual who's in that role? Is it a matter of sticking to a consistent interpretation of the Constitution in general? Or is it an angle of, as long as it's within the bounds of the law, even if it's far out there, it's okay? So I guess my question is generally, then how do you determine that? How do you draw those lines? Or what is your kind of framework for going about that? Thank you.
Well, first and foremost, an advisory function where the lawyer is rendering an opinion, for example, from the Office of Legal Counsel as to what the president can do and what the president cannot do. The obligation of the lawyer is to give the absolute best advice based on the legal precedent. Advice is not advocacy. So that memo, which might be sufficient to submit to a court to defend a CIA officer who has waterboarded someone and not get sanctions under Rule 11, is not the same as a memo from the Office of Legal Counsel to the General Counsel of the Department of Defense and the CIA telling them what the law is. So when you're advising a client, you have an obligation to inform the client as to the different arguments, and there are going to be arguments sometimes where the law is ambiguous. In the private sector, this tax shelter may work, this tax shelter may not work. These are the reasons why. But you have to give honest advice. In the private sector, if you don't, you're going to end up getting sued. But in the government, unfortunately, we don't have that check on the lawyer. They could write a memo from the Office of Legal Counsel telling the president could do something the president can't do. And for example, President Biden had a memo that he could forgive all the student loans. I mean, that was just very obvious that wasn't gonna, that dog wouldn't hunt. And they need to tell. I mean, they need to be honest. OLC's been doing this for a long time. Obviously, that's nowhere near as big a deal as a torture memo. And the other problem is a lot of these memos are not even disclosed by the Office of Legal Counsel. And that includes not just the ones that are classified, like the torture memos, but other stuff. I don't know what the Office of Legal Counsel is saying about whether you can blow up a boat in the middle of the waters off of Venezuela, but I can't conceive of a reasonable argument for that. But apparently they have one. So the obligation of the lawyer is to give the best advice you possibly can. Now, there are going to be variations in terms of interpretation of how far we go on executive power. And I think at a point where the client is insisting on doing something unreasonable, first you absolutely have to say that's outside a reasonable interpretation of the statutes and the Constitution. And then at a certain point, to resign. So, what is the absolute best interpretation? We don't know. Always there is going to be a range. But when you have torture memos, and you have whatever kind of memos are being drafted that would tell the President of the United States he can enter the executive order sanctioning Covington and Burling and Perkins Coie. I mean, there's some executive orders that are so far beyond the pale that whatever type of advice the President is getting isn't advice at all. You just have a lapdog over there in the Office of Legal Counsel. And say there's a problem. It's been a long time coming in the OLC, and it's just accelerated under this administration. Your client is the United States of America, and I think an important part of that, just to remember the supremacy clause of the Constitution, that the statutes and the treaties of this country are the supreme law of the land. And that defines a lot of who your client is. Is not the man in the Oval Office or the head of the agency or the Attorney General of the United States. It's the United States of America, and their Constitution has a lot to say about that. That's the best I can do on that.
Other questions? Yeah, actually, just a question for Rachel about the Northwestern episode that you talked about. And I sort of, this is a question/comment, but I guess I wanted to just ask you to talk a little bit more about a couple of aspects of the case that I don't think you really focused on, but I thought might have like broader lessons. And those are one, so as you said, it was a House committee, but kind of hand in glove with the administration. So I think it's useful to think about all of these other kind of intermediaries or other actors whose various powers can be, kind of force multipliers for an administration that wants to target adversaries. But if I'm not mistaken, I think that so the clinic decides to sue, and as you said, the committee drops the case like that. There's like a hearing scheduled, and I think it maybe was right before the hearing was going to begin. And the other thing I think maybe you didn't mention, and correct me if I'm wrong, but I think that the clinic sued both the House committee and Northwestern. Like I think the university was on the other side of the V. And so I guess, are there lessons in terms of if you are targeted and the larger institution is not going to have your back, there may be ways to go it alone with scrappy, civil rights lawyers, which I think is what happened in that case. And that also, maybe the committee has come back and tried through other sort of soft methods to harass the clinic or to get things from them. But it does seem to me significant that the clinic just stood up to this House committee, and the effort went away. Like it just seems to hold broader lessons about sometimes not just the kind of moral righteousness, but the efficacy of pushing back.
Yeah, thank you. So I completely did not focus on the fact that they also sued Northwestern, but yeah, I'm happy to talk a little bit more about how that drama went down. On your last point, though, I don't come from the big law world, but if you're going to find people who are willing to stand up, I do think you'll find them in the civil rights and the criminal defense space, because we're very used to being unpopular. And so it's not quite as shocking as it might be in some other instances. Now, I haven't been the subject of a, demand letter from a House committee, and I don't know how I would feel about it. But yeah, so what's really, there's a lot of interesting permutation to this, but the clinics as a whole so the reason Northwestern was sued, so it's two professors who sued the House committee and their own university. Neither of them are tenured, so this is a bold move by their part. One of them was the professor who was actually named and called out and criticized in the House committee letter. That's Sheila Beatty. The other one was not mentioned at all, but because the letter was seeking data on all 20 clinics and on their policies for case selection, et cetera, that professor decided to join. So I am not privy to all of the internal discussions, of course, that went on, but that's so two people decided we're going to go together, and not on behalf of all the clinics, but we are going to sue. And the reason they sued, not just the House committee, but Northwestern University and the university president and the chair of the board of trustees by name, is because the university president, at the behest of the board of trustees, was telling them to turn over the records. So what Northwestern wanted to do, or at least told the clinics to do, is give the House committee everything they're asking for. And that's when the lawsuit was filed. So yeah, the ongoing implications are probably at least somewhat obvious. This all happened in the spring. That's when the lawsuit was filed. And so the demand was made in March. The lawsuit was filed shortly afterward. And like I said, the House withdrew. But there are a lot of ongoing tensions related to the administration's pressures on universities and pressures on high-profile universities like Northwestern. So my understanding is the university and the board of trustees have continued to try to engage the clinic in changing their policies, changing their case selection. I'm not sure if they're trying to get Professor Beatty still to stop representing this group of protesters. That was certainly one thing that did happen, and I'm not sure where the clinics land on that. But yeah, there are all sorts of implications. There are implications for the professors and their job statuses, and I don't know how it'll all unpack. I do know that my compatriot, the director of clinics at Northwestern, is dealing with a lot. And I can tell you St. Thomas, and we're not at all alone in this, many clinics and clinic directors are drafting policies about what do we do if demands are made on us related to our case representation and clients, and the university is telling us to capitulate. And I'm not saying that because this has happened at St. Thomas or that I think that our university president would do that. I'm not at all saying that. But it's important to have ideas in place. And we did not have a policy for this before this past spring, but we have an almost finalized one now.
Did the committee ask for information that's protected, client information under Rule 1.6? Did the committee ask for that type of information too?
I could go back and look at the letter. I don't think it's protected client information. If anything, they're seeking more student data that could have been protected by FERPA. So there were concerns that student data was implicated. Certainly, like course evaluations and things. I mean, there's student input on that, whether that's considered student data. But I don't think they were specifically representing client information or requesting client information.
So this is a slightly broader abstract question that all of you have been making me think about, which is, are lawyers safer in big groups or not? Like, as being part of an institution, because it's a way like part of the dynamic of the law firms, right? Is sometimes you have individual lawyers, some of whom wanted to fight the executive orders, but other people at their law firm said, no, this client's too dangerous. We talked in the first panel about, thank God the Microsoft and Amazon were okay with standing up for the First Amendment, but what if they weren't, right? Then things would be different. Law school clinic, right? We talked about the Northwestern clinic is under pressure from the broader Northwestern University. So you might think in some ways the lawyers would be safer if they were not attached to a medical school that could be threatened with consequences. But on the other hand, when you see individual lawyers who, have to take out a home equity loan, might just be unable to continue in their jobs without some cushion. You think maybe it's better to have institutions like the Federal Defender's offices or other institutions. One of my co-clerks, Aaron Murphy, is, with Paul Clement, they decided it's better not to be part of a big law firm anymore because big law firms get under lots of pressure not to represent things. So I sort of, as I hear these stories on both sides, obviously it seems like there's, if you go, there could be trouble. If you stay, there could be double. But how do we think about that as a general lesson for if you want to kind of try to insulate yourself against the threat from government tyranny? Is it better to hang separately or hang together?
I've always had concerns about big law firms and client conflicts of interest. I've taught professional responsibility now for almost 30 years. The larger the law firm, the more client conflicts you have. I've been focusing mostly until recently on the private sector conflicts, and the larger law firms almost always urging for more flexible interpretation of conflict rules. And I think this is carrying over into this space as well. The large law firm that's dependent on corporate clients doesn't want to alienate the President of the United States. And whether it's what's going on at Paul Weiss or any of the others, with very few exceptions. I think the Jenner Block firm is, I would just say they make Burt Jenner proud of the way they stood up against this. He was a great litigator in Chicago for many years. But that's the exception. The big law firms are under enormous financial pressure to pay their associates, to pay the partnership draw. We have this obsession with rankings of law firms by profits per partner. I mean, it's amazing. We're ranking law firms by profits per partner in a profession that is supposedly committed to justice. This is absurd of ranking law schools. It makes no sense. This business of the firms want to get bigger and bigger by size and more profits per partner. And of course, that makes them sitting ducks for abusive tactics from the executive branch of the United States government. Smaller law firm, I think you got a lot more flexibility. You may not make as much money. And so if you're in the profession for the money, maybe you go with a firm that's going to, capitulate when the almighty dollar speaks. But I would say the smaller law firms. The clinics, it's a problem. The universities are dependent on federal money, and they're putting the squeeze on. I noticed some of the wealthiest universities in this country are capitulating, with the exception of Harvard University. Harvard's standing up to them. Of course, they got $55 billion. I guess at a certain point you have enough money, you can stand up to the tyrant. But you go the next level down, and very, very wealthy universities capitulating right and left to the President of the United States. And I think that's going to affect clinics as well, unless the clinics take a stand. And you got to protect your clients first and foremost as a lawyer. And if there's anything, whether it's a house subpoena or anything else, that's going to undermine your ability to represent your clients, you got to stand firm for that. You don't stand firm for your institution. I've used the phrase colleagues covering for colleagues. We see this going on in the government, in the Republican caucus, certainly now in the United States Congress. We've seen it with the Democrats, too. We see it in the universities. But those on the law faculties who actually really practice law and teach in these clinics, which are so important for the education of our students, need to take a firm stand in defense of their clients. And if that means suing your own university, go right ahead.
Yeah, I'm just going to really briefly say I think we're probably not better off in big groups, but we need groups for moral support. So I think that I think the fact that so many independent and small firms have been the ones taking on unpopular pro bono cases, standing up to the administration, criticizing it, I think that speaks to, I think in some ways it's easier to make difficult decisions when there's only a few of you as opposed to finding consensus in a mass. But it's hard to keep doing it if you're alone. And so I think you need people, whether it's part of your firm or your agency or just other moral support. But I think the group matters, but maybe you don't want to be tied to the group.
I was actually I'm going to maybe dispute your question a little bit because I don't really think there's an answer in the sense of, there's a lot of dangers when you're practicing law. There are a lot of threats. And you solve for one threat and you create vulnerability to another threat. And that's not new. I think there was, it was you. You said it. On the previous panel, maybe it was Kate. Sorry if I'm not remembering who said what. But, a lot of attorneys feel threatened in various contexts all the time. There's the judge who's chiding you. Even in a bigger sense, I know criminal defense attorneys are prosecuted. That it doesn't happen all the time, but it happens regularly enough that we're certainly all aware of it. And of course, so I don't think that some of this is in a sense a sort of a matter of preference. I think of when I'm talking to a client and I say, look, there's no clear answer here. Some of this depends on who you are. Do you want to take a chance that may go really badly but may go really well? Do you want the sort of more certainty? Different lawyers have different answers to that question. And I think that the answers to that question of sort of how you want to be as a lawyer, how you want to practice, in some degree drives sort of the place that you practice in and the vulnerabilities and the strengths of those different structures of practice.
By the way, I should have one more thing, a message to law deans and university administrators. If you want to stand up for the rule of law, at a minimum, tenure all of your clinical professors who've had some time at the university, because the last thing that people should have to worry about is losing their job because some big donor puts pressure on the university. I'm amazed that there's some law schools that aren't tenuring the clinical profession. It just makes no sense to me. We need some protection. That doesn't solve the problem if there's an FBI raid or whatever on our house with a search warrant, but it at least gives some protection. I have that protection, and I don't know why people who are leading our clinics are going out on the front lines there dealing with this issue wouldn't have at least that minimum job protection.
Thank you all for being here today. My question is for Professor Painter and relates to your analysis of the Reich v. Prussia case. I'm curious if you anticipate a similar result from the current Supreme Court to the German Supreme Court, or if you see differences in the statutory or constitutional landscape that could demand a different result here.
Well, it's obviously a different constitution. Article 48 had specific powers expressed to the executive if a state violated its duties to the federal government. So there are duties from the states to the federal government clearly articulated. But it also had provisions in the statutory implementing legislation allowed a veto from the legislature, from the Reichstag, and they figured out a loophole. They're loophole lawyering, avoiding. So this supposedly great philosopher, Carl Schmitt, who, by the way, is favored still today by the extreme left and the extreme right in the legal academy. There's an entire Oxford handbook to Carl Schmitt. So his ideas have not gone away, but they figure their way around it with the legislature without a session. But what the Supreme Court of Germany did, it wasn't just a clear, well, the president can do anything he wants type opinion. It was a very nuanced opinion, but it allowed the president to implement this order through Chancellor von Papen, and it was enough to set the precedent So when there was a fire in the Reichstag the next year, the new chancellor, Hitler, was able to basically do the same thing throughout the entire country. The grave danger is that democracy you can lose gradually or you can lose very suddenly. And the last years of the Weimar Republic saw an increasing desire for a strong center. Everyone wanted another Bismarck. If we had another Bismarck, we wouldn't get humiliated by the British and the French, and we could protect ourselves from the communists. There are grave dangers there. I don't know what our Supreme Court would do. I hope our Supreme Court would stand up for the rule of law and tell the president there are clear boundaries. I'm worried about, though, in Chicago case and the Los Angeles case and others, that you're going to get a very narrow opinion that doesn't articulate the clear boundaries as to what you can do and what you can't do with deployment of federal troops for domestic law enforcement purposes. The general rule under the Posse Comitatus Act is that is prohibited, subject to very few exceptions. Insurrection Act being one of them, and Title X being another. I just hope the Supreme Court, instead of just narrowly deciding some very small issue, and basically punting or giving a wishy-washy opinion like the German Supreme Court did in 1932 in Reich v. Prussia, is willing to articulate some clear boundaries as to when what the National Guard under the President's command can do. That's different than if Governor Walz wants to deploy the National Guard. That's a different conversation. We'll see what this court does. They spent a lot of their time avoiding issues when it comes to dealing with the executive, except for the very broad, sweeping opinion Trump versus the United States, which went so far beyond what they needed to do, even if they wanted to slap down Jack Smith. That language, some of that language in that case is, I think, positively dangerous.
Okay, do we have another question before lunch? One more. We've got one more.
Thank you all so much for being here today. My question is pretty general, so I would actually like to open it up to members of both panels, if that's okay. But I'm a 2L, and it's been a really interesting time to be a law student, I think, to say the least. And my question is, as law students and as we enter the profession, what kind of practical advice do you have for us to build our resiliency? And be able to kind of stand up in the ways that we've heard talked about today, in a way that also kind of protects our own wellness and well-being.
I'll answer first because I may have to duck out for a quick radio interview. Stand up for what is right. Don't follow the money. That's awfully hard to say when we're charging such exorbitant price to go to law school these days, which is a whole other conversation about the way legal education is structured and the cost, because we're interfering with the right of clients to representation when people can only afford to go represent the very well-to-do. But to the extent you possibly can, find a career where you're doing work you enjoy, where you're willing to vigorously defend your clients. You're not focusing on the money, the rankings of law firms, or the other stuff that's used, and now being used, I think, by the administration to manipulate the practice and undermine lawyers' zealous representation of their clients. You've got a job to do what, and adhere your own values, your concept of what's right or wrong. You don't let anybody tell you what that is.
Sure, I'll just say something briefly to that point based on serving on the admissions committee for 5 years and some data that other people have gathered about law students entering versus graduating, which is that I saw this in personal statements, but the data also backs this up. Most people entering law school are able to articulate their own value-based reasons for why they're going to law school. You have good reasons for why you came. A lot of people, by the time they graduate, are more externally motivated, unfortunately, than the internal motivations that brought them there in the first place. And we as law schools contribute to that, certainly. It's a problem in the profession. There's so many ways that you're categorized and you're ranked and you're told what how to view success and whether you're successful. So it's not law students' fault entirely or even largely for becoming that way. But I think the more you can connect with the reason you pursued this career, and that doesn't mean like you knew what kind of lawyer you wanted to be, but whatever your reason was for pursuing the career, I think the more that you can stay connected with that, or if your reasons have changed, but they continue to be internally motivated for whatever those reasons are, I think you're able to develop resilience because you're still doing what matters to you. It's very easy to burn out pursuing other people's definitions of success.
Anyone on the earlier panel want to weigh in?
Yeah, I appreciate that question so much. A couple of things, and I'll be borrowing from some things I heard from the panel. I think most people want to live lives of meaning. Most people want to live lives that matter. And a lot of that comes from your relationships in your communities, maybe your faith, maybe things that have nothing to do with work. But a life of meaning, a life that matters, if you're lucky, can include your work life. And one of, I think, the advantages and sometimes joys of the legal profession is that it is possible to do work that matters, but it requires intentionality and choice of the sort that folks have been talking about here. And then also, as Rachel said, you also need to take care of yourself. And even if maybe it's not such a good idea for lawyers to band in groups, maybe for all sorts of reasons, we need to find communities either inside the law or outside of the law. And in choosing those, you might think about the attributes and values that are important to you. There's lots of evidence that shows that if you hang out with generous people, you become more generous. If you hang out with curious people, you become more curious. If you hang out with kind people, you become kinder. And this is a very different thing from hanging out with people who share your identity or your experiences, as we have to figure out a way to live together even when we don't agree about how to live.
I feel like that is an excellent note for us to end on. So can you all please join me in thanking this terrific panel?
Welcome back, everyone. Please continue to eat. We're going to get started with the second half of the Law Journal's Fall Symposium on the constitutional rights of lawyers and law firms. My name is Dan Kelly. I serve as Dean and Mengler Chair in Law here at the University of St. Thomas School of Law. Before we get started with our keynote fireside chat interview, just wanted to say a few words of welcome to everyone, most especially our students who have worked very hard already to make this day possible, and I know are going to be working very hard on the symposium issue as well. So thank you, students, and also our staff here at the University of St. Thomas. Whether it's the setup of the atrium, the wonderful lunch, our AV, the staff really goes above and beyond to make events like this happen. Also want to thank all the faculty, both those here in Minnesota from the University of St. Thomas, my colleagues, and the University of Minnesota Law School. I know there's several colleagues from across town here. And all of the faculty and distinguished experts and lawyers who are here, not only from Minnesota, but literally across the country. It's just a distinguished group of folks from Fordham to UC Berkeley. And so to have this level of talent for this symposium on such an important topic, we just really want to thank you. I think this topic, and as you've heard this morning, is super important at this moment. So in a way, it's one of those topics that's timely, and at the same time, it's a timeless topic in terms of what are the constitutional rights and responsibilities of lawyers and law firms. So from the First Amendment to the Sixth Amendment, and from professional responsibility to legal ethics, having expertise and deliberate discussion, civil dialogue on these topics is super important and germane. And especially in light, many of the faculty, staff, and students here at the University of St. Thomas know that we're just launching a new strategic plan, and there's really three components to becoming academic excellence as one of the top national law schools as we look to build. And I think this topic really serves it well because what we're focusing on is academic excellence and love. And sometimes when I mention love and lawyers in the same sentence, they either laugh, chuckle, or are very surprised. But our focus on love of knowledge, which is what we're doing in the symposium, and love for students and all of our students, not only in terms of what you're doing for the symposium, but also how you'll benefit in terms of reflection on these important topics as you are aspiring lawyers. And then finally, love of neighbor. And sometimes when we think of love of neighbor, we say, well, who is our neighbor? And it can be a wide definition, as we've learned. And there are many neighbors that we encounter in law school, including within our community. And sometimes we think of love of neighbor as those who are least fortunate, and that is definitely true. So Rachel Moran, as director of our clinics, all of our clinics focus on love of neighbor. Sometimes what we don't think of as our neighbors in the legal profession are actually fellow lawyers. Those people who are in the bench and the bar are our neighbors. And so thinking about their rights, their responsibilities, how we deal with them on every level, local, state, and federal, that's something we're all called to do. So I could not be happier about this topic. And last but not least, I'm going to let Professor Paulson introduce our distinguished guests for this fireside chat. But I did want to say a special thank you because we're truly honored and blessed to have the Honorable J. Michael Ludig here with us. When I was in law school, which was between 2002 and 2005, Judge Ludig was on the U.S. Court of Appeals for the Fourth Circuit. And nowadays, everybody talks about, wanting to clerk for a quote-unquote feeder judge. That is a judge who will send clerks to the Supreme Court of the United States. At the time, Judge Ludig, I think, not only was one of those feeder judges, but actually probably because of the number of clerks that he sent on in the legal profession to clerk for the Supreme Court, almost defined that term. So whether it was the Chief Justice or Justice Scalia, Justice Thomas, among others, there are so many future legal professionals who are doing such good work today. And so I just want to personally thank him. I was not, my grades and activities weren't good enough to probably get a clerkship with Judge Ludig at the time, but I just want to let all the students and our faculty and staff know how lucky we are to have him and Professor Paulson on the next panel. So please join me in welcoming him.
Thank you, Dean Kelly. So you were in law school between 2002 and 2005? I graduated in 85. I'm 20 years older than you? Oh my gosh. I am honored to have, I never clerked for Judge Ludig, but I worked for Judge Ludig when he was head of the Office of Legal Counsel from 1989 to 1991. So in 1991, I left Department of Justice to become a law professor, and he left Department of Justice to become a U.S. Court of Appeals judge, and we haven't seen each other in 35 years, but it's great to have you here. Thank you so much for coming. Let me just give a quick rundown of his resume. Because. Well, okay, we'll make it very quick so we get to the points. He's a graduate of Washington and Lee University for his undergraduate, where he spoke last night and got on a plane this morning from Roanoke just to make it here, and he's flying home to Florida tonight. He went to law school at University of Virginia. He clerked for then Circuit Judge Antonin Scalia, and then clerked on the U.S. Supreme Court for Chief Justice Burger. After that, I might have some of the things out of sequence, but he worked in the White House counsel's office. Is that where you met John Roberts? You were sidekicks in the young years of the Reagan administration. Did a stint in the major practice, Davis Polk, I think, and then became Principal Deputy Assistant Attorney General for Office of Legal Counsel. That's a mouthful. Principal Deputy Assistant Attorney General. Can you say it all with me? Principal Deputy Assistant Attorney General. In the first Bush administration, and that's when I went to work for Department of Justice for a second time. I'd been a prosecutor before that. And as Dan Kelly said, Michael was appointed to the U.S. Court of Appeals for the Fourth Circuit, sat in Alexandria, Virginia, and very quickly became one of the most well-known, prestigious, respected conservative Court of Appeals judges in America. He was often talked about as a prospect for the U.S. Supreme Court. I think he interviewed with W at one point. We won't go into that. He is a feeder or was a feeder. That's the colloquialism for a Court of Appeals judge who finds his clerks becoming U.S. Supreme Court clerks. And I think you've actually generated some offspring in terms of federal appellate court judges. Here in Minneapolis, my friend David Strauss, who was a colleague of mine at University of Minnesota, is a Ludig clerk who Ludig fed to Clarence Thomas. Michael then was on the Court of Appeals from 1991 to, I want to say, 2006, when he became general counsel at Boeing. So he's also worked as an in-house counsel in private practice and knows these issues from that perspective. So you kind of retired from Boeing, but recently he's come out of retirement to be back in the public limelight and public service in connection with issues concerning the Trump administration. And if I'm correct, Michael, was the triggering event that first brought you sort of back out of retirement the request from the Vice President's office for legal advice on the issue? This is in 2020, so this is Vice President Mike Pence. January 2021, and the question is, the constitutional question is, can the Vice President, when he opens the votes to count and tabulate the electoral vote tally for President, can the Vice President refuse to count some of the votes? This was the, I want to say scheme. Is that too loaded a word? This was the scheme that was being put forward by the Trump administration as a device for overturning the result of the 2020 election. Was that the Vice President could, when it came to opening the votes on January 6th, say, well, these votes are disputed, we won't count them, we will send them back, and thereby throw the election to President Trump as opposed to President-elect Biden. So can you tell us that story? We're just going to get some of these background issues.
Well, thank you, Michael, but first, thank you, Dean. It's a great privilege to be here in this glorious atrium. If I had had the privilege to go to law school here and in this atrium, I might have made something out of myself. I'm here because of one man, and that's Professor Mike Paulson. I would do anything for him. I worked for him for 2 years back in 1989 to 1991, and I learned everything that I know today from him in those 2 years, and that's barely overstatement. But we were instant friends back then because he was already a giant of a human being, and incidentally, a giant in the law already. But we haven't seen each other in 35 years, and when you get to be my age, you say things like I said to Michael a few minutes ago when he told me we had not seen each other in 35 years. I said, well, you know, going forward, we ought to at least try to get together every 35 or 40 years. And that's, I guess, a sad commentary on getting not old, but older. So these generous introductions have already just filled my mind with fundamental things of life that I would like to talk to you all afternoon about. But I could have never foreseen that the dean would talk about love. It was in 1989 and through 1991 that I first began to talk in terms of my love for our lawyers at the Department of Justice in the Office of Legal Counsel. I've carried that forward my entire life. Dean, I don't really care what anyone says, and I'm proud to talk about love in any context, and especially in the context of lawyers and teams of lawyers who travel through life together. But at least I want you to understand the genesis and reason for that. In my view, if you truly are good and you know what you're doing and you're cast into a position like I was then and then subsequently as a Court of Appeals judge, you surround yourself with the kind of people like Michael Paulson and others, and then my law clerks. And then you tell them that you love them. And the reason you love them is first and foremost because you truly love them. And incidentally, you love them because you understand that you are no one without them. And when they pull together to support you in whatever context, then as the head of OLC and later as clerks on the Court of Appeals, you understand that you need them more than they need you. And that's the essence of love in that professional context. But Dean, thank you for giving me that note to lead off with. But on my lawyers at OLC and my law clerks, almost to the person, these were the finest people first, and the finest lawyers in America at the time. And I'm so proud of them. When I read something that Michael sent me on the way in, and he had listed some of our lawyers back at OLC days and told me where they were and what they were doing, and it all just washed back over me that this was the finest team in America. And then on the law clerk thing, Michael, I always said, and today still say, that it was the greatest privilege of my life to have the 51 law clerks that I did. And I was honored that during my years on the court that the finest minds in the legal profession wanted to come clerk for me. And so it was thereafter my honor to recommend them to the Supreme Court. And all 51 of them got offers to clerk at the Supreme Court. And a couple of them...
For 51?
2 or 3 didn't go because they got their offers a year or 2 later.
Okay.
But yes, and then I'll just tell you one vignette to lighten the mood. So, Scalia, of course, was a dear, dear friend of mine. He was the most brilliant judge and justice ever to sit on the Supreme Court, bar none, and it's exceedingly unlikely that there'll ever be one his equal, right? And we had a wonderful relationship. So he took some number of my clerks, and I'm sitting there one day, and I had sent someone highly credentialed to interview with him, and Scalia calls me, and this is how we talk to each other. He goes, "Ludig." I said, "Yeah, what do you want?" He said, "What was that?" And I said, "What's what? I don't have time for this, boss. What are you talking about?" "You sent me this person to interview, and he just walked out of my office. What was that?" And I said, "You know what? He is the perfect candidate to serve as your law clerk because he's absolutely brilliant. He has the highest credentials ever known to man, and he doesn't have a clue what's going on in the world. He's the most suitable person to serve as your law clerk that I could ever imagine." So,
Who was that?
well, I'm not going to say.
I just gotta know. I just don't know.
So to get to the issue that we've gathered here today to talk about, I've been doing this retirement gig since January 6th, going on 5 years. And by doing it, I mean, it's been the greatest honor of my life, but I've been speaking around the country, doing interviews, doing television for going on 4 years now, almost every day of every week. And it all began on January 5th when Richard Cullen, the vice president's close friend and outside counsel, called me. Richard and I were longtime friends, and it was on the evening of January 4th, I think. And he said, "Judge, do you know somebody named John Eastman?" And I said, "Well, yeah, I do." And he said, "Well, I said, "Why are you asking?" And he said, "You don't know, do you?" And I said, "No, I have no idea. I don't live in your world of politics." He said, "Well, John Eastman was in the Oval Office this afternoon with the president and the vice president, and he told the vice president, in the presence of President Donald Trump, that the vice president could essentially overturn the election 2 days thence." And I said, "Well, you can tell the vice president that I said that he has no such authority under the Constitution of the United States." And Richard said, "I told him that." And I said, "Well, what do you want me to do?" And he said, "Well, I don't know, but this is very important." I said, "Well, I gather, but what do you want me to do?" I said, "I'll do anything you want." He said, "Well, I just need to think about this." And so the next morning, I get up early, like most of you do, around 4 a.m., and he calls. I'm in Vail, Colorado, and he says, "Judge, we have to get your voice out across the country immediately." And I said, this was a serious call, right? I wasn't playing any games. I knew what he was referencing, but I said, "Well, Richard, I'm retired. I don't have a platform. I don't have a public office. I don't have an office, a private office. I'm out here on holidays with my family in Vail, Colorado. I don't even have a box of stationery, and I wouldn't know who to write something to if I had a box of stationery." And he said, "Judge, this is urgent." And I said, "I understand." He said, "I'll call you back in 5 minutes." He calls me back in 4 minutes and says, "Have you thought of anything?" I said, "No." "I'll call you back in 5 more minutes." Calls back in 5 minutes. "Have you thought of anything?" "No, Richard. I'm racking my brain, but I don't even know what you want. I have no idea." "I'll give you 10 more minutes." So he calls back in 10 minutes and he says, have you thought of anything? And I said, Richard, I opened a Twitter account a couple of weeks ago, but I don't know how to tweet. And he says, perfect. Do it now. And I said, well, what did you not understand? I told you I don't know how to tweet. And he says, it doesn't matter. The clock's ticking. Please do it now. So in the interim with these phone calls, I had been typing out on my phone what I would say. And I went down to my office there in Vail, not knowing how to tweet a thread or whatever you call it. So I just got in touch with my son, who's a tech genius, but a millennial, and I said, "Look, John, I got to tweet something very important now." And like all millennials, he said, "Dad, I don't have time for this. You and Mom are dinosaurs. You're going to have to learn how to do this at some point, and I'm busy." And parents are smarter than kids give them credit for being. And I said, you listen to me, young man. You either tell me how to do this right now or I'll cut you out of the will. So he groused and said, well, Dad, do you know how to open your emails? I said, I do. He said, open your emails. I've sent you the instructions for a Twitter thread. So I slammed the phone down on him, opened my email. There were the Twitter instructions for a thread. So I transposed my iPhone text into a Word document because that's the only thing I knew how to do, and I knew how to create 140 character whatever tweets. I did it. I reread them very carefully. I was very calm because that's the way I'm always calm when I'm under the greatest pressure because I can't function if I'm not. So I read over it one time for typos, pushed the button, and I had no idea that anyone would ever see it. And I didn't even know why I was doing it, nothing. And Richard called me in 5 minutes and he said, your tweet's on the front page of the New York Times. And I said, Richard, just leave me alone. And I hung up on him. Fast forward to January 6th, I'm sitting in the same office there in Vail, and I get two cryptic emails from two former law clerks. Judge, what are you doing? I said, this is sort of me. I hate to reveal this to you at this late stage, but I said, what are you doing? And they wrote back both separately and said, I said, I'm out in Colorado. It's the holidays. And what are you talking about? And they said, well, the vice president is on his way to the Capitol for the joint session. And he just released a letter to the country, to the nation, and saying that he's not going to overturn the election in an hour. And he cited you. And I said, really? I said, can you send me that? And they said, sure, and they sent it. So the only point that I want to make about the tweet for all of you young people in the audience, and I had a chance to make this point last night at Washington Lee, every single one of you and every single person will arrive at a moment in their life, a moment of decision, and it will be the most important decision that you'll ever make. And this usually occurs in one's private life, right? But it also occurs in public life. And what I was, I was always thinking about that moment from the time, actually, that I was in college, because it was fantastical to think about, pick somebody, George Bush, when he's told that, about 9/11. But, I've just always been fascinated by that. And so, but in any event, on January 6, 2021, when I got the call, I didn't have any decision to make. I had made the decision over the previous 40 years. Think about that in your own lives, whether it be in your public life or your private life. And to go with that, so John Eastman called me a couple days later and said, Judge, I heard that you gave a legal opinion to the vice president that said he couldn't overturn the election. I can't imagine that you and I were thinking about this much differently, if at all. Can you send me a copy of that legal opinion? And I said, John, I didn't need a legal opinion. He said, well, you didn't? I said, no. There was no legal opinion to be given. And even if there were a legal opinion to be given, I would have never given it to Donald Trump. And I told that equivalent story to the Congress of the United States when I testified.
Well, we're very grateful you sent that tweet. Can you imagine what would have happened if Pence had refused to count electoral votes that were certified as the actual votes and upended the election?
Well, I had to do a lot of thinking about that for my testimony, because that was essentially the first question they asked. Liz Cheney ended up asking it, and I said that had the vice president refused to certify the election for Joe Biden, America would have been catapulted into a paralyzing constitutional crisis from which it could not ever recover. The paralysis point that I made to the Congress was one that you need to know about today, but suffice it to say it this way: under all of the laws of the United States, and of course the Constitution of the United States, if the vice president had refused to certify the election, there is nothing and no one in the United States government who would have the authority and power to do anything about it. And I had been asked about that for months prior to January 6th by the media, and so I had worked my way through all of that for purposes of pre-January 6th. But the point was that it's unimaginable, Mike, what would have happened.
Do you view Trump's efforts to overthrow the election as tantamount to an attempted political coup d'etat against the Constitution?
Well, we don't want to get in a technical language. I mean, it's not a coup d'etat because he didn't use the military eventually, though, as we know, he did think about having the military seize the ballot boxes, but I don't like to use words that are that colloquial, if you will. I don't know that I ever have used the word coup, because it's more serious than a coup. It was, as I said repeatedly, the gravest constitutional crime that an incumbent president could ever commit against the Constitution and against the nation. And by the way, I want to say this and develop it if we have time. The founders of this great nation, almost 250 years ago, next year, almost 250 years ago today, with a magnificent prescience, they foresaw this man and these times. And as I said in the Atlantic article, you'll recall, Michael,
just came out.
They believed to a certainty that if this man and these times ever came, that it would represent the demise of the nation that they had founded. And sure enough, that time has come. And this country is being tested now like never before. In Lincoln's words, tested as to whether this nation or any nation so conceived can long endure. It's nothing less than that today, students. Nothing less than that. And all of you are the only people who can save this country from that demise. And you have not only a special qualification, but you have a special obligation to the country and to your profession and to the law to do so. If you lawyers don't do it, it will not get done. We were having a little sidebar with some friends earlier and talking about the fact that lawyers, your profession, have by and large refused to stand and defend America's democracy, her Constitution, and rule of law. Think about that when you leave today. The legal profession. This is the only time in American history that I'm aware of that the nation actually needs lawyers. And just like its politicians, its lawyers have been nowhere to be found.
Judge, let me ask you a couple of hard questions. I do this when I interrogate my students, so I try to push them. So I'm going to push you on the Constitution. Did our system of separation of powers and checks and balances fail to fulfill the founders' vision when it failed to impeach Trump, when it failed to criminally prosecute him? What is your reaction to that?
Well, the Constitution and specifically the separation of powers within the Constitution didn't fail, and it will never fail. What failed are those individuals who we charged with the protection and preservation of the Constitution and the laws of the United States. The people. Now we can say, for the first time in 250 years, that the Constitution is little more than a prophylactic. If the people who administer the Constitution are going to fail to administer the Constitution, then we might as well not have it. And that's where we are today.
So that includes Congress, the House and the Senate in failing to remove Trump?
Okay, well, we judges, we don't dodge any question. That's
Sure you do.
I don't.
Okay.
But I just wasn't going to answer that one. No, for this reason, what Michael is trying to provoke me into admitting, but I will proudly admit it, notwithstanding his provocation, is that the Washington Post asked me to write an essay, whatever you call it, the week of the second impeachment on the question of whether Donald Trump could be impeached, convicted after he had left office. And I did all my, original research and thinking and writing, and I wrote for the Washington Post that if the Senate didn't convict Donald Trump before he left office, then it could not thereafter convict him, complete the impeachment process, and then, if it had the votes, bar him from holding office, the office of the president ever again. And my dear friend, Professor Lawrence Tribe from Harvard, he and I have walked this road, with arms locked for the past 5 years. And by the way, he is the most brilliant legal and constitutional mind in all of history. And he still is today at age 82 or 83. But he had written a piece for the Washington Post earlier in which he had said that, yes, the president could be convicted by the Senate and barred from holding office thereafter under the Constitution.
After he'd left office.
After he left office. And so Larry and I, again, were very close at the time, and Larry pled with me to re-examine the question because so much was at stake. And of course I did it. I thought about it as seriously as I've ever thought about anything because Larry wanted me to do it and because it was that big a deal to the country. But I finally concluded and told Larry exactly why. And for today's purposes, suffice it to say that I, of course, understood the argument, even the argument under the text of the Constitution. But I concluded that was simply not what was ever intended by the framers of the Constitution. And incidentally, during the ensuing days, when the Senate and the House the Senate was going to vote, I was in. Most of the Republican leadership was in touch with me about what I had written. Let's just put it that way. And I've made clear to every one of them, that look, I don't do politics. I said, I really could care less what any of you people do up there on Capitol Hill. I have zero respect for all of you. But that is my constitutional analysis. Just like all these politicians, Scalia used to call them great Americans. Just like all those great Americans up there, they wanted me to go public and talk to this. And I said, no, I don't do that. But many people have discredited me with having the Senate refused to take up the matter.
I think I disagree with you on this opinion, but we won't go into that. Let's go to the next step at which arguably the potential for checks and balances to operate to prevent Trump's election, and that's an issue on which you and I do agree, and that's Section 3 of the 14th Amendment's disqualification of persons who engage in insurrection or rebellion, having previously sworn an oath to support the Constitution. Judge, so was Donald Trump in your view, constitutionally disqualified and ineligible to be a candidate in 2024?
Yes, there's no question whatsoever under the Constitution of the United States. But this is where I have the only fun, really, with Michael Paulson and Will Bode, who left when he learned that I was speaking next. So it may not appear it, but I'm considerably older than Michael and Will Bode, and Larry and Tribe and I had been discussing this very issue between ourselves and no one else in the world until I was tweeting or Twitter, whatever you call it, and I somewhere it was a Will Bode tweet or some reference to this article that Professor Paulson and Professor Bode would write. It was forthcoming in the Pennsylvania Law Review, as I remember it. And of course, I read the summary that day, and that was a signal moment in my life and legal career. When I read those words that these two men had done the original research and work and analysis and concluded that yes, Donald Trump was disqualified under Section 3. I mean, just the adrenaline just ran through me hot. And I was just like almost shaking, going, oh my God. Now, I paused to make again the point that I want you to take away. It wasn't that somebody had said it. It was that this man and that man had said it and done all of the original work for the first time in American history. So, in other words, that instantly they affirmed what Professor Tribe and I had been talking about and believing, but had never done the work to determine. So within minutes, I remember this. I paused long enough to collect myself, because I never say anything, not one single word in public in any form that is not well considered to the point of final conclusion. But I had been thinking about this issue, but in any event, I tweeted within minutes to the world something like, this article by these two men will quickly become the most important law review article ever written. Something like that, right?
I suppose. I'm not on Twitter. I never read this.
No, no one can even reach you, and that's the problem, I was trying to reach Michael. No way, I couldn't.
I think I was on an island in northern Minnesota.
Yeah, and the first of the two that I reached was Will Bode, and I said, Will, oh my God. And Will, he said, yeah. And I said, yeah. I said, do you realize what you two have just done? And with modesty or naivete, and I think it's probably the latter, no one's ever accused either of them as being modest, they didn't have any idea, I believed, in what they had done, but I did. And, for instance, that afternoon after my tweet, I was asked to come on 2 or 3 national television networks to discuss their article. And of course I said, well, no. And they said, well, Judge, you just tweeted it's the most important thing in American history. You got to come on television. I said, it is. But I ain't going to nowhere until I've read the thing. Mm-hmm. But that is, there's very few of us in life who ever get to do even one thing of true consequence and significance for the nation or the world. But that's what that article was, Michael.
Well, thank you. It did generate some litigation. The Colorado Supreme Court held that Trump was ineligible, and it went up to the U.S. Supreme Court right about 2 years ago now, and our article was so convincing that it garnered 0 votes at the Supreme Court in a case called Trump versus Anderson. They said that the Section 3 disqualification could not be enforced through the mode of state election laws. And so Colorado's exclusion of Trump from the ballot was overturned the day before their March primary. So I'm going to get Michael to say something provocative. Was the U.S. Supreme Court complicit in leading to the crisis of the Constitution? Did the Supreme Court, well, I'll leave it there. Were they complicit? What do you think of Trump versus Anderson?
Okay, so I was going to ask you which crisis you were talking about, but we don't need to talk about any crisis. But that gets us into the Supreme Court today, and of course, in Trump against Anderson, the Supreme Court didn't decide anything. They emphatically, to use Chief Justice John Marshall's word, refused to decide what the law was. In a complete abdication of their constitutional obligation to the country. Professor Tribe and I wrote a piece for The Atlantic shortly thereafter. I think it was titled, "The Supreme Court Betrays the Constitution and America." It was not an option for the Supreme Court of the United States just not to decide it. That's what they sit for God's sakes.
But they did say that Colorado could not enforce the exclusion. They did reverse the judgment of the Colorado Supreme Court, which effectively put Trump on the ballot. I mean, that is a decision. They didn't dismiss it for lack of jurisdiction on a pretended grounds or call it a political question. They did resolve the case. Is it their fault?
Well, listen, I got no problem getting to that question, but first off, let's be clear with everyone gathered here. Just like was going to occur in Trump versus United States sometime later, whatever they decided, and I don't even know what they decided, it had absolutely no support in the Constitution of the United States. None. And so I've said many times over now that turning for the moment then to Trump versus United States, that case was an abomination.
This is the presidential immunity from criminal law case.
Right. So, and that's a case that I happen to know something about from Michael Paulson. He taught me everything I know about presidential power under the Constitution of the United States. But no, in all seriousness, I've spent my whole life talking and thinking about presidential power under the Constitution of the United States. And listen to me when I tell you this. I know for a fact that for 250 years of American history and constitutional jurisprudence, the idea that the President of the United States might not be criminally responsible for a crime had never once been suggested.
Michael Hurd.
With good reason.
Can we go another 10 minutes? Can we? Okay, we're going to go another.
Sure, with good reason. From the day this country was founded, through the Constitution of the United States, through Nixon against the United States, up until the day this Supreme Court decided that case, that was never the law. And I was pleased to join President Joe Biden in calling for an amendment to the Constitution to overturn that. The day it came out, I said it was the worst case ever decided by the Supreme Court, far worse than Dred Scott or Korematsu, because of the structural damage that it did to the Constitution, in particular the separation of powers.
Okay, I got to ask you, what were they thinking? What was motivating them?
Well, what I've said repeatedly is, of course, in some empirical sense, we don't know what's motivating them. But with a case like that, and even the immunity case is different from the Section 3 of the 14th Amendment case, because of what it said, in light of the law and the Constitution, and then listen to this, and in light of the narrowest possible issue presented, namely, could Donald Trump be prosecuted for attempting to overturn the 2020 presidential election, period. From all of that, we can most reasonably conclude that the Supreme Court of the United States did that just to save Donald Trump. And that's why, it's because of their decision that Donald Trump is the President of the United States today.
Oh, we just made some news. To put it colloquially, is it your sense that they were in the tank for Trump, as people would put it, or was it an act of deliberate assistance to Trump, or were they in some sense being cowardly and coy? You understand that?
I understand
what I'm getting at.
I understand what you're talking about. So let's take each of those three strands. I don't know what "in the tank" means, and I'm not going to acknowledge that I do. I don't talk like that, and you don't either. But as to the other thoughts, for all these years, I have said as to the Supreme Court, when asked the question why, I said, well, it's either out of fear or favor. a phrase that you all recognize. Of late, I've concluded and said publicly that there's no question it's out of favor, not fear.
Okay, couple more provocative questions, and then we'll set up the next panel. How to put this? Okay, Trump is not disqualified. He is not subject to criminal prosecution, and he campaigns explicitly on a platform that this is to vindicate his winning the 2020 election and his unjust treatment, and he's going to engage in patterns of vengeance if he's elected president. And he's elected president. Does that wipe the slate clean of past wrongfulness? Does his election in 2024 essentially supersede any Section 3 disqualification or authoritatively interpret the Constitution? Have we, the people, interpreted the Constitution contrary to the way you and I thought it would be correctly decided in support of Donald Trump?
Well, that part is easy. Of course not. You know, that nothing that the public does, or the Congress or the president does, for that matter, can change the law or change the Constitution or change facts or change truth. Now, there is still today, I think I can report to you, right as distinguished from wrong, truth as distinguished from falsity, fact as distinguished from fiction, honor as distinguished from dishonor, duty as distinguished from abdication of duty, courage as distinguished from cowardice. And there is still law as distinguished from lawlessness. No matter what anyone tells you, no matter what Donald Trump tells you, Donald Trump cannot rewrite history itself, though he's trying. The damnation in it is that the President of the United States is trying to rewrite all of history, to cleanse history of his wrongdoing.
I have about 15 more questions, but I'll just cut to the one at the end, which is kind of the punchline of this. Is if you see this as a lawless presidency, both in terms of its creation and presumably many of the actions Trump has been taking, and we've been focusing on the orders directed against the legal profession. What do you see as the way out? Is there a way through this? What is the solution, or is there no solution? Is law functionally irrelevant when it's overcome by superior power? And then what are we to do? What should law students do? What should law professors and lawyers do?
Well, that's a fun question in many ways, but to answer the funnest part, there is no law when it is overcome by something else. And that's why when the Atlantic asked me to write a piece for Donald Trump's first 100 days in office this time. I did so, and I titled it "The End of the Rule of Law in America." And I analyzed there the 10 or 12 signature initiatives of the president in his first 100 days, and I concluded that every single one of them was either unconstitutional or otherwise in violation of the laws of the United States. And in the 6 or 7 months since I wrote that piece, every single one of them has been struck down by the federal courts or at large. You ask, well, what's the Supreme Court done? The Supreme Court's done nothing for 10 months. It's acted what I call illegitimately. The lower courts strike down Donald Trump's actions. Donald Trump takes them to the Supreme Court claiming an emergency. What's the emergency? The lower court ruled against him. What does the Supreme Court do? It says, yes, this is an emergency. We will take that case into the bosom of the court. What has it done with some? I think we're up to 20 of those cases now. Having taken the case into the bosom of the court under the pretext that there's an emergency, within days or at most weeks, the Supreme Court issues an order. Not one word of explanation, not one word of reasoning, not one word of analysis, nothing. The decision of the lower court is stayed. So Donald Trump has been able to do whatever he wanted to do for what will be the first 2 years of his presidency. Because as you all know, well, first off, the only case that's made it to the Supreme Court is the tariff case. The court just heard argument. It'll decide it in the summer. There's your 2 years. So what I said in this article is that as to all of these cases, it doesn't really matter now what the court decides. It doesn't matter. By the time the court gets to these cases, if it ever does, the damage to the Constitution and to the nation has long been done, and it's irreparable. But before I walked off, I only had one thought before I came up here today, Michael. I sent it to you, and of course, you dismissed it.
No, I have it.
No, I know. So the only things, I've only been able to write or say two things in the past 5 years that I wanted to write or say. The first one, I wrote a piece on Substack for Independence Day 2025. The second piece I wrote for Constitution Day 2025, September 17th, and I reversed the order, but basically in the first piece, I wrote what was in effect a new Declaration of Independence, and in the second piece, kind of a new Constitution. But I titled the second piece, America's Grievances Against Its King on Constitution Day 2025. The 27, and I had 27 grievances that America has against its king, Donald Trump, to parallel the 27 grievances that the American colonists had against King George III and the British Empire in the text of the Declaration of Independence. And of course, one of those was the subject of this symposium. So with only the further explanation that I wrote both documents, tried to write them as if the American colonists were stating these grievances. I'm going to read you the one that's on point for your symposium. He has unlawfully extorted our business companies and our legal profession, conscripting them into his personal service, and they have bribed him in return for his approval and for his official and his personal patronage. Our companies have betrayed their shareholders, and our law firms their clients and the law to gain his blessing and secure his official and personal favor. I'm looking down at the note, and the next grievance was apt today too. He has bludgeoned our colleges and universities on pretext and contrary to law, demanding control over their governance, quashing their academic freedom, and cracking down on free speech in our educational institutions and on our campuses. So that's why we're gathered here today, to talk about what he has done to the legal profession and also what the legal profession has done to us in return.
And on that cheerful note, Judge Ludig, thank you so much for coming here. It is great to see you again. Thanks so much for your presentation, and we will let you go and catch a flight back home. Let's give Judge Michael Ludig Michael Hurd. Should we take 15 minutes and start this next panel at 2:15? Okay, thank you.
Good afternoon. My name is Jerry Organ. I'm here to moderate our final panel of the day, and it is a great privilege to introduce from the far right of mine, Sybil Dunlop from Green Espel, Professor Mike Paulson from here at the University of St. Thomas School of Law, and Professor Alan Rosenstein from University of Minnesota Law School. Our topic for today, the first thing we do, let's kill all the lawyers, government coercion, and the role of lawyers in preserving a free society. Sybil, please get us started.
Excellent. I'm going to talk for about 15 minutes and then pass the baton. And as we noted at the end of the last panel, we ended up someplace pretty dark. And I'm going to go back to pretty dark, but I'm going to start with a moment of lightheartedness. We just heard a great response on the last panel to the question of whether Trump attempted a coup d'etat. And my favorite answer that came about during those trying times was on Twitter, and I saw someone respond, "Technically, it's not a coup unless it comes from the coup d'etat region of France. Otherwise, it's just a sparkling insurrection." So with that response, I will have our moment of lightheartedness and then turn back to these trying times. My name's Sybil Dunlop. I'm a partner in town at a law firm called Green Espel. We are a litigation boutique, and my practice is primarily business litigation. I do have a practice, though, that has come into contact and been impacted by the events of the Trump administration repeatedly and through multiple different ways. And so I was going to talk a little bit in my 15 minutes about how that's happened, and also end with some things that I've been doing to try and push back in the ways that we can, what feels good in my practice, what I'm trying to accomplish, in the hopes of giving folks a palette of options that might be fun things for you to pick up on and start to do as well, if the events of today are leaving anyone feeling like they need to do a little bit more. So I'm going to talk about my practice, my clients, my law firm and how it's been impacted, and then sort of the view that I have into the system that we all participate within, our judicial system. And so starting with my practice, about 10 years ago, I'm primarily a business litigator, but I was angry that people were not selecting women to lead their trial teams, primarily for selfish reasons. Running trials is my favorite thing in the entire world. And so I started doing a lot of research about it. I'm also an IP litigator, and it's something like 7% of women are leading IP teams. And I realized that a lot of it was unconscious bias. People didn't see women as leading trial teams, and so they had a hard time envisioning it and choosing those people. And so I started teaching about unconscious bias, and I want to say I liked the band before it was cool, right? So this is 10 years ago. I start teaching a program on unconscious bias, and it leads to founding our firm's DEI practice, where a group of us end up getting hired to go around the country and teach about diversity, equity, and inclusion, help groups come up with ways to achieve those goals, and to do better. I also got to lead some more trials, but this was something I was not anticipating coming out of this work. So as a result of that, a lot of my clients turn to me when they are thinking about diversity, equity, and inclusion. And I know we're talking today about the executive orders that have come out regarding law firms, but as I'm sure everyone knows, there are also executive orders that have come out regarding diversity, equity, and inclusion. So in January 2025, Trump issued an executive order titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. And he said within 120 days, the Attorney General has to submit a report that will identify key sectors of concern, specific enforcement measures, potential investigations into large corporations, several of which are clients of ours, and then litigation and regulatory actions to ensure compliance. And people were scared. I want to be very clear that in talking to our clients, we emphasized what this doesn't do, right? And what it doesn't do is it didn't change any existing anti-discrimination laws. It didn't require companies to stop lawful DEI. But it also didn't tell anyone what an illegal DEI program was. And when we're thinking about all of the executive orders that I know you all talked about this morning and what they were aiming to accomplish, this I put in a similar bucket. What Trump was aiming to accomplish was to have people self-police. He surely can't go after everyone, right? He can't go after every single law firm. He's not going to issue an executive order about every single firm. But if he does it for a few key ones and people stop doing what he doesn't like that they're doing, now he's had the effect of creating laws without having to do it. And so the threat that the Attorney General, Pam, was going to come out with a report and everyone was going to have to deal with the fact that they might be named in it, we saw people starting to adjust backwards. And one of the things I started doing was really going in and working with clients to talk about how you could continue to achieve your diversity goals in compliance with 100% of the laws. There is nothing illegal about, say, trying to ensure fair review of resumes or making sure that everyone is eliminating unconscious bias in their interview process. So that's what we did. But the effect it also had, both in getting clients to self-police a little, was also changing the risk landscape for everyone. So before these actions, there was the risk of course, lawsuits from traditional discrimination plaintiffs. And the world changed, right? Now we have lawsuits from reverse discrimination plaintiffs with a changing legal landscape, and then we've got this threat of federal investigations and executive orders. And it also amplified, as all of you can probably remember, the social risks. So people are on social media, and there was a fight among folks, one side or the other, affecting our clients in terms of compliance. So my practice itself has been impacted by the executive orders, even if they haven't specifically impacted any specific client. How about my firm? My firm found itself in the middle of trying to navigate, of course, the question of whether or not to sign on to the amicus brief when Perkins Coie filed suit against Trump. And that was, of course, because there was an executive order about Perkins Coie, and there was this call for folks to sign the amicus brief. My firm is a lovely firm. We are a democracy. And so every single one of the 27 lawyers at my firm has an equal vote. We have monthly meetings where we all decide what to do, and so we were going to vote on this question. And I don't want to reveal any one particular person's position, but I will tell you what the conversation was. The conversation that our firm had was about how we can be the most effective in representing our clients. And we do a lot of work for pro bono folks who have immigration issues. We do a lot of work on Voting Rights Act issues. We were in front of the Minnesota Supreme Court just last week on a Voting Rights Act issue. So the question was, would us signing this amicus in any way impact our ability to do our best on behalf of our clients? Would a spotlight be drawn, onto us in a way where maybe we could just stay under the radar and keep doing the good work that we felt like we were doing that was making an impact on people's lives? And this, I think, gets to Judge Ludwig's question, right? When are the lawyers going to speak up for themselves? We are so good, I think, at being advocates for other folks that we were nervous about taking a moment to speak up for our own profession. And here's what changed our mind. There was an op-ed in the New York Times over the weekend when we were deciding what to do. And it was by the senior partners at the law firm of Kecker, Van Nest, and Peters. And they wrote, I think, an excellent piece of lawyerly persuasion in the New York Times about why their law firm was signing on. And they talked about, if it's not us, if not lawyers standing up for lawyers, who will? We are the advocates. And I think it changed the lens of our firm from thinking about ourselves just as advocates for others to also needing to be advocates for the system in which we work and the system in which we make our living. The very sort of principles that we were coming to work every day to live for others, we needed to do it for ourselves. And so we signed on. And this is just an excerpt from the amicus. But here's the interesting thing. Of course, it was mostly litigation firms that signed on. Any big firm with an M&A boutique or an M&A practice was more likely not to participate. And I think that says something about agency capture. When you look at M&A firms, they have a lot of government regulation. They get worried about who is going to give them permission to do the deals that they want to do. Whereas we're a litigation boutique. We just sue people, right? We're used to being in fights with people. And so it made me realize the freedom that I have and the freedom that the folks at Kecker, Van Nest, and Peters have, and a bunch of other folks who signed on, like Patterson Belknap and other litigation firms that are fairly famous. And I am very grateful to the fact that I do have this freedom, the freedom to speak out. I'll also note, though, that on LinkedIn, you can see who looks at you. And later that week, somebody from the DOJ looked at me. And normally I would think, oh, it's just a friend from law school. But in these times, I thought, oh no, am I going to be investigated for my DEI practice? Nothing has happened yet, but it's the sort of thought where I realized 5 years ago never would have occurred to me. I just would have thought a good friend from law school was looking at my profile on LinkedIn. And now you have, doubts creep in, and you're left with these doubts. So I'm going to close by talking about the system and my fears for our system as a result of everything that's happening. I work at a private law firm. I think of myself as a good person, but also a person who likes making money and who has some student loans, as many of you may also do. I have always thought I will feel completely comfortable representing anyone who is willing to pay me to do so because I believe in our system. We have an adversarial system where I assume that I'm going to do my very best job for the person that has hired me. The other side is going to do their very best job within the bounds of all of our ethical responsibilities. And if we do that, the truth should prevail, right? That is our system. But all of a sudden, if we have a system where our president is going after law firms for asserting certain positions, representing certain pro bono clients, I am very concerned that we are pulling out the Jenga pieces that are supporting the entire system. Because our system, the truth-finding nature of our system, depends upon this adversarial process and people feeling very comfortable representing disparate sides. So what have I done? And this is the part where I'll share what I'm doing. And if we have moments to chat after, I would love to hear what you're doing because I think it's important to share these things. I'm doing a couple of things. I have signed on to co-chair Justice Gaius's reelection campaign. She's on the Minnesota Supreme Court. No one's running against her yet, but I would sign on. She's amazing, by the way. I would also sign on to serve as any single person on our Minnesota Supreme Court's co-chair, because I think it is so important to have an independent judiciary and not have folks running against them for political reasons. The folks on our Supreme Court were appointed by a process where there's a commission that picks the best people, and that makes me feel really good about how they were picked. If we look at Wisconsin, of course, we have political ads and a lot of money coming in and people now politicizing that process. And I think once the system gets politicized, we just heard from Judge Luttig, he has some doubts about the Supreme Court these days, the US one. And so I love that our system has more independence, and I'm fighting to protect that. The other thing I'm involved in is with Lisa Brabbitt. Is she still here? I saw her earlier. We work on the Infinity Project together, and we help prepare women for judicial interviews and get them ready and help them prepare their materials and help some really great people become judges. And encouraging and finding and telling your friends that you think will be good judges that can stand up for the rule of law to do it, I think is something really important that we can all be doing these days. So that is where I find hope and I find energy in doing these things. And the last thing I'll say is, if you see something, say something. If you see somebody bending the rule of law or having it bend in a way that suits their political beliefs instead of what we all know, hey, this says right here, this case says X, we got to do X. That's when you have to say something. And it will, as Judge Luttig said, all of us will face that moment when we have to say something. And I want to know that I will. Thank you.
Hello, it's me again. I wasn't originally planning to be on this panel. I am a late innings, last-minute replacement for Abner Green at Fordham Law School. Abner's mom passed away just 2 days ago, and I said, don't worry about it, we will cover for you. So Abner could have done a much better job than I'm going to do, and I haven't got my thoughts completely organized, but I've assured the editors of the Law Journal that I'll produce this in some written form, hopefully more coherent than what I say today. But I've cobbled together a couple of thoughts. They're not entirely random thoughts, but I'm not sure how they'll fit together. We'll see if they fit together by the time I'm done talking. So I think I'm going to try to make three broad points. The first is the point about these executive orders being unconstitutional. That was the main thrust of the first panel, and I will point to the obvious unconstitutionality of the Trump executive orders targeting lawyers. They violate the First Amendment in innumerable respects, and as a couple of people said at that first panel, they violate other provisions of the Constitution. They are unconstitutional about 3, 4, or 5 ways. So that's my first point, is the broad unconstitutionality of these executive orders. That leads me to my second point, and I'm going to muse about why would they issue them? What's the purpose then? Trump doesn't like to be a loser, but his legal position is a sure loser. What is the point? What is the motivation, the purpose of promulgating these transparently unconstitutional orders? And I'll speculate about a couple of those. And then finally, I will address this question of what is the right response? How are lawyers, law students, and the legal profession supposed to respond to this? So I hope to eventually at least grapple with the question, can he do this? And the answer is no. And what can be done? Who will stop him? And I'm going to end up with something of a little call to arms to the legal profession to rise up and resist the slide toward tyranny. So that's my 3 points. I'll try to spend about 3 minutes on each of the 3 points. Jerry will give me the hook if I go over. First point is the obvious unconstitutionality of these provisions. And that was my first reaction to it. That's what led to my email question to Will Bode. Is this the most clearly unconstitutional thing he's done? And Will's answer was there are things that are actually more unconstitutional, but this is plenty unconstitutional. And I think it's plenty pernicious. let me just sketch out my core arguments for why it's unconstitutional. Under the First Amendment free speech clause, I think it's pretty straightforward that lawyering is speech. Sometimes it's literally speech. Sometimes it's literally press. Sometimes it's literally petition. It falls right within the middle of the strike zone of what is protected by the freedom of speech. The lawyers engage in speech. Is the lawyering activity protected by the freedom of speech? And I think the fact that it is a profession does not take it out of the realm of being protected advocacy. It is protected by the freedom of speech. And the government's actions abridge that freedom of speech in a number of ways by imposing punishments, penalties, and by threats. The case that was alluded to earlier this morning by Kate Shaw, a case called National Rifle Association versus Vullo, is the illustration of that, where a New York state official attempted to get at the National Rifle Association by getting at companies that would do business with the National Rifle Association. And it builds on a case from the 1960s, but the basic premise is extremely important in this area, is that you can't abridge somebody's speech by using the vehicle of pressure you put on other people, right? You have regulatory pressure you can apply to other people, and then we'll whipsaw that into pressure on lawyers. In addition, I think that these executive orders violate the right to counsel, Sixth Amendment rights. My good friend Dan Farber alluded to that. I think they violate due process of law. They attempt to compromise the integrity of the legal process. And this might just be a pet theory of mine. I think that they violate the principle of Youngstown, Sheeton Tube versus Sawyer. Now, you all endured that as like your first or second or maybe your third big case in constitutional law. Harry Truman seizes the nation's steel mills for a good and valuable purpose. He wishes to avert a strike because he wants the material to keep manufacturing for steel because there's a war on. There's a Korean War. And the obviously correct holding of Youngstown Sheeton Tube is that the president cannot legislate on his own, and he cannot engage in a seizure of an industry. In a sense, Trump is legislating on his own and attempting to seize an industry and to conscript lawyers and marshal the legal industry in his favor. Early on, we quoted, it's part of the title of this panel, first thing we do, let's kill all the lawyers. The Trump administration is not literally, I at least hope they're not literally, trying to kill all the lawyers, but they are certainly trying to cow, conscript, co-opt, and coerce the lawyers as part of its agenda for how it's enforcing things. On the same premises that would permit the administration to do this to lawyers, they could do this to any industry. On the same principle that the government on the same principle that would enable the government to single out law firms for penalties or disfavored treatment on the basis of the government's disagreement with their views, their opinions, their affiliations, their client representation or positions, the government might single out any private business for punishment on the basis of its owners or customers' speech, expression, or association. This builds on a point that Dan Farber made in his contribution to the symposium. If a law firm represented a client or hired a partner that the president dislikes or who has opposed him in the past, they, and even more perniciously their clients, can be blacklisted on the theory of Trump's executive orders directed to law firms. So I have a disturbing hypothetical to propound to you. Imagine that Donald Trump takes great offense at this conference and thinks it's just terrible that this University of St. Thomas employs a hateful law professor like Michael Stokes Paulson. Could the government say, we will not hire any University of St. Thomas students or permit them to be engaged in any activities on behalf of the federal government unless and until St. Thomas fires Professor Paulson. That's exactly the situation here, where the government is saying to clients of law firms, we will have no dealings with you as long as you're associated with this, with these law firms. So that's my first point, is these executive orders seem to me clearly unconstitutional. They're unconstitutional about 3 or 4 different ways. So it seems to me very likely that Trump is going to lose these cases if they go up to the Supreme Court. I put a question to the first panel. Do you think the administration will even try to appeal these cases, and what would happen at the Supreme Court? And the short take of the prognosticators was that the Trump administration knows not enough not to seek an emergency overturning of the injunctions against these executive orders because they fear they would lose, and they've put it on a slow burn. I think that's possible. They may not even appeal them altogether because they are such losers. Okay, Trump doesn't like to be identified as a loser, and that brings me to my second point. What's going on here? Why was he doing this? What is his motivation and his purpose? And it seems to me there are 2 motives going on. And at first they sound somewhat in tension with each other, but I think the more you think about it, they kind of work hand in glove. The one motivation is it's purely personal. Okay? It is a matter of Trump's personal vindication, his desire for vengeance, and his personal vindictiveness. To quote the Godfather movies exactly backwards, it's not about business. It's strictly personal. And I think that there's a lot to Trump's taking these actions purely because he can and he wants to. Even if he doesn't win, he can give his opponents a bloody nose. If he hits you first, it's going to hurt at least a little bit. And even if you can't win, you can harm. And I think Trump is trying to take down as many of his opponents, even if he goes down with them. Now, lurking in all this, Trump's urgent desire for vindication and vengeance, I speculate is that deep down, it's possible he is fully aware of his guilt, right? There's sort of a consciousness of guilt that's going on, and thus the extraordinary insistence on denying or suppressing or repudiating the idea that he could have done anything wrong. This is why he's pardoned all of the January 6th insurrectionists, and it's why he is insisting on prosecuting the people who prosecuted him. Sort of an, I'm not guilty. I want to insist that I'm not guilty. They are. As if the longer and louder he proclaims that, the more likely he is to convince people it is true, and maybe even to convince himself that it's true. So that's the personal motive. But related to that is, I think, a political motive that seems at first to be different from it, but actually works together. Because I think his political motive is to concentrate power, because he must not ever lose again. He must not ever leave office. If he loses office or loses power, he's vulnerable, and he doesn't wish to become vulnerable, lest he be held responsible. So I wonder if the point of these executive orders is not that they ultimately will ever be enforceable, but that they will be used to intimidate, cow, and chill others, to suppress speech, to deter, punish, and essentially impose a tariff on resistance to the administration. Pulling back and looking at the big picture of what Trump is trying to do in so many of his actions in this first year in office, I think most of them fit into one of these 3 categories. And that is the centralization and concentration of power in the executive branch in the person of Donald Trump specifically. He's issued very early on orders directed toward eliminating intra-executive branch resistance to whatever he does. Firing all the inspectors general, firing the JAG officers in the military, firing career prosecutors and FBI agents, firing military leadership, and choosing a cabinet not for its competencies, but for its sycophancies. In terms of constitutional power, I think he quite probably has the power to do all of these things, but the objective is to enable him to do whatever he wants and not to have anybody in the executive branch or the military question him when he does. So that's category one. And category two of his objectives is the elimination, evisceration, or evasion of checks and balances of other branches. To overawe Congress. Congress has been wonderfully pliant for him and has not been enforcing its constitutional prerogatives, and to threaten or defy the authority of courts, to cow the courts, the judiciary, into complacency. One need not go quite as far as my old boss, Michael Ludig, in saying that the Supreme Court is totally ruling in Trump's favor as a matter of favor, to acknowledge that they are backing off from what should be the legal principles that they would have embraced in other situations. I think there's a lot of fear going on. And that brings me to the third category in which his executive actions seem to fit, and that is the attempted suppression of dissent and opposition. And I think the orders directed at law firms are in part directed toward that goal of we must tear down any potential centers of resistance, institutions of resistance, universities, law firms, states, anything that could go in the way of Trump accomplishing whatever he wishes to suppress. And I think that this is a intentional suppression of freedom of speech. Which brings me to my last point, my third point. Can I take another minute, Jerry?
You're good.
What's to stop him? Who's going to stop him, right? Even if these orders are flagrantly unconstitutional, that's only half the problem, right? The answer to the question of can he do this constitutionally is no. But the answer to the question of can he do this anyway, practically, and achieve it is uncertain. And that's where I would echo Michael Ludig's point about the vital role of lawyers and of the legal profession. Tocqueville, Alexis de Tocqueville in Democracy in America refers, sometimes flatteringly, sometimes not so much, to the legal profession as the natural aristocracy in America, the ones whose democratic inclinations and anti-democratic reservations in combination serve to protect the integrity of a free republic. I think that's right. I think lawyers are potentially formidable block of opposition committed to, in theory, the rule of law and defending the Constitution. As Spider-Man put it, with great power comes great responsibility. Or as Jesus put it, to whom much is given, much will be expected. And I actually want to challenge anybody who watches this program as a CLE and challenge all you lawyers, future lawyers and law professors, to recognize that you have great power and you have great responsibility. You have been given much and much will be expected of you. And that's part of why it is so terribly disappointing and demoralizing to see so many large law firms caving like a house of cards in the face of Trump's attempts to coerce them into supporting the administration's regime. There are costs to courage, right? But there are also profound costs to cowardice. and costs of compliance and costs in acting in complicity and in collaboration. So I will end with something of a moral call to arms. And this was in an email that I'm plagiarizing my own email to a former student who had asked about this and who I'd bumped into at a Paul Simon concert earlier this spring. It said, law firms and lawyers must resist with every resource at their disposal and must never bow to, never acquiesce to, never compromise with this proto-authoritarian regime. An authority that can punish, intimidate, or threaten law firms into compliance with the unlawful whim, prejudice, caprice, animus, or mere preference of the dictator can do the same to any private business, enterprise, or association. First thing we do metaphorically is kill all the lawyers. Next, we kill the universities. The next targets become private associations or businesses of all kind. Businesses compelled to bow or else be bullied, boycotted, or blacklisted. If lawyers, Tocqueville's natural aristocracy, and protectors of democracy in America do not stand against this regime now, who will and when? For American lawyers to fail now, for lawyers to fail now, to fail to stand up to and challenge the beginnings and the burgeoning of a nascent authoritarian regime in the United States would be, well, already is, a failure of our duties as lawyers and a failure of our responsibilities to the rule of law as officers of the law and members of what should be a noble profession. Not to stand up to the regime, to accede to the regime's wishes, is to compromise irretrievably the independence of our profession and our ability to zealously advocate for our clients and to abandon our responsibilities as lawyers to our society.
Hi, everyone. Thank you for having me. So, and I apologize, I wasn't able to attend this morning and this afternoon's remarks, but my understanding is that this event is really focused on the Trump EOs against the law firms. So I want to talk about the role of lawyers, but I want to talk about it from a slightly different perspective, in part because I never worked at a private law firm, so I don't have that particular perspective. But I did work at the Department of Justice before entering academia, and I think there's a lot to say about that institution and how it's doing right now. I graduated from law school, I clerked for a year, and then I spent a few years at the National Security Division in the Department of Justice. I was a policy lawyer, basically a lawyer for lawyer for lawyer for lawyer, so many levels of abstraction. And I didn't spend that much time there. I spent about 2 years and change, and this was at the end of the Obama administration, the first couple of months of the first Trump administration, and then I left, came to Minnesota. And although that time was quite short in the scope of my broader career so far, in some ways it was the most important part of my legal career, and I suspect it will always be the most important part of my legal career, even though I hope to be wheeled out of the classroom sometime 50 years from now. I love the Department of Justice. I think it is an incredible institution. And when I was there, one thing that I was quite surprised about was how little politics mattered. I don't even mean partisan politics. I mean literally the level of political appointees that sit on top of the Justice Department, the Attorney General, the Deputy Attorney General, and then the Assistant Attorney Generals, the people who run the Criminal Division and the Civil Division and my division, the National Security Division. Obviously, those political appointees set priorities, as was appropriate, right? Elections have consequences, and part of those consequences should be how the Department of Justice operates. But they certainly didn't set legal conclusions. And the level of respect, I mean, maybe for some of them it was annoyance, maybe for some of them it was fear, but I think for most of them it was respect that they felt for the civil staff. I mean, not me, I was new and didn't know anything, but for, my bosses who had been there for a while and knew things, was immense. And I think the main reason why it was such a well-run institution. So that was then. What, by contrast, is now? So earlier today, President Trump made the following on his Truth Social platform. Now that the Democrats are using the Epstein hoax involving Democrats, not Republicans, to try and deflect from their disastrous shutdown, all caps, and all other failures, I will be asking AG Pam Bondi and the Department of Justice, together with our great patriots at the FBI, to investigate Jeffrey Epstein's involvement and relationship with Bill Clinton, Larry Summers, Reid Hoffman, JP Morgan, Chase, and many other people and institutions to determine what was going on with them and him. This is another Russia scam with all arrows pointing to the Democrats. Records show that these men and many others spent large portions of their life with Epstein and on his island. Stay tuned, 3 exclamation marks. But that's not the thing that bothers me. Here's what bothers me. Later today, so a few hours ago, Attorney General Pam Bondi, quote tweeted this with the following. Thank you, Mr. President. SDNY U.S. Attorney Jay Clayton is one of the most capable and trusted prosecutors in the country, and I've asked him to take the lead. As with all matters, the department will pursue this with urgency and integrity to deliver answers to the American people. Oh boy. That bothers me much more than what the president said. Because this is the chief law enforcement official of the United States, engaging in, and this is a family audience, so I'll just call it bootlicking and let you all use your imaginations. The problem is that government lawyers face 3 duties. One is to their client. They are lawyers for a client, and that is the executive branch or the president or however you want to call it. Another is to the Constitution, and a third is to their profession. Those 3 are not fully overlapping. Right? Those 3 are not fully overlapping obligations. Now, DOJ culture has managed this through one really critical norm, and that is you have to be prepared to resign at any moment. And this is not meant as a sort of dramatic, statement. This is meant as an actual baseline expectation. And because I know many of you, most of you are students, I will say this, because this was a piece of advice given to me before I started the Department of Justice, and it was to pre-write my letter of resignation. Just keep it generic, don't sign it. Just keep it really simple, to whom it may concern, I hereby resign my position at the Department of Justice, sincerely. And then print it out and put it in your drawer, right? I don't know if I ever printed it. I wrote one. It was on my computer at least. I don't know if I ever printed it out. But my advice, the advice that I got, and the advice that I have given to many people who I have advised, and I'm the one member of my faculty at my law school who worked at the Department of Justice, so I'm DOJ guy. I'm the guy that students the office that students wander into, and they say, hey, do you want to work at the Department of Justice? And I say, hey, it's an amazing place, or this is what I used to say, hey, it's an amazing place, doesn't matter who's in charge, but you have to do this thing, right? Remember, you have to do this thing. You have to pre-write your resignation letter. And this is important because not everyone can take a job having pre-written that resignation letter, right? Some people are differently situated. Some people have financial obligations. People have family obligations. When I joined the Department of Justice, I was very lucky. I had a lot of financial freedom. I didn't have a partner. I didn't have a child. I was just some, 25-year-old kid in Washington, D.C. And so resigning from DOJ would have been a very, upsetting experience, but I don't know, I would have shaken it off in 48 hours and gone on with my life. Not everyone is in that position, right? But if you're not in that position, you can't take that job. I mean, you can take that job, but you're taking a big risk. And when, in the first Trump administration, students would wander into my office and they say, hey, I don't love what their guys are doing. Should I go work for DOJ? I'd say, yeah, probably, it's fine, right? Just rewrite your letter of resignation. One of the great unfortunate things about this administration, that's not a top 3 thing, but it kind of hits close to home, is that I can no longer give that advice. Students will come to me and they'll say, hey, I have this opportunity, and I'll say, look, ordinarily I'll say, can you pre-write your letter of resignation? But now, the level of reputational risk that I think you take by just being associated with, unfortunately, I don't think can be described anything other than criminality, which is an odd thing to say for the Department of Justice, but here we are, is so high that the advice that I give is quite different. And the problem is that this is actually not good advice from the perspective of broader society. I think it's pretty good advice from the perspective of the students whom I'm advising, and I'm their professor, they have come to me, right? I am obligated to give them advice that is in their best interests. But from society's perspective, you should want my students, right? And we should want Professor Paulson's students here to go work at DOJ, right? Because you need good people doing the good work. And unfortunately, we are getting to a point where that is no longer a tenable situation. And this worries me because at the end of the day, for mostly constitutional reasons that I think Professor Paulson has outlined a little bit, if the so-called unitary executive theory applies anywhere, I think it applies pretty well to the Department of Justice. We can argue about Fed Reserve independence and some FCC commissioner, but I don't know. I'm pretty sure that the president is the chief law enforcement officer of the United States. And I'm pretty sure that he is constitutionally entitled to order the prosecution of anyone he wants, right? Now, if the prosecution is invalid, the courts will deal with it on the back end. But I actually am pretty sure that he is allowed to make that decision as a matter of his control over Article 2. And what that means is that what has stood between us and kind of a wholesale collapse of the Department of Justice as a rule of law organization has not actually been the law, it's not been statutes, it's not been the Constitution, it's just been norms, right? And there are moments, right, and there are moments in American history where those norms are tested, and so far they have come through strengthened, right? The last time this happened, it happened a little bit in the second Bush administration with Alberto Gonzalez and his, defenestration, as it were, which in retrospect you look back at it and you think, my God, what's small ball compared to what's happening now? But he was run out of polite company for a while, actually. The bigger version of this obviously was the post-Watergate reforms. But all those things did was create a set of norms that then survived for some amount of time. And what are norms? Well, they're just the willingness of people in the Department of Justice to pre-write that letter of resignation and submit it at the right time. So it's a real dilemma, right? It is a real dilemma. And I don't know how that is solved. At some point, here I'm maybe a little more optimistic than Professor Paulson. I think Trump will leave in 2028. I think he's an old man. I think, American democracy will endure. This is a big ship. It's a big ship, and even Trump is a small rudder. It's hard to turn a big ship at 180 degrees. But when he leaves, the Department of Justice will be in a disastrous place. It will be a sad shell of an institution, right? I think only last week or 2 weeks ago, I read a New York Times article about the fact that they can't fill slots, right? It's an empty building. It's insane, given how competitive it was, when I was applying. One of my close law school classmates, she was in my section, was a good friend, was Maureen Comey, the daughter of FBI Director Jim Comey, a fantastic lawyer in her own right, a real hotshot sex crimes prosecutor in SDNY. She was fired a few months ago for, what is it, corruption of blood? I think that's the constitutional term, right, for having the wrong parentage. And she is sued for wrongful termination. They can't find anyone to respond to the lawsuit, right? Like they can't find anyone. And so in 2028, the Department of Justice will be a sad shell of an institution. And the question will be how to rebuild it. I think the legal profession will have to think very hard about, frankly, social sanction for all of the apparatchiks. And I think we as a legal profession like to be above the fray and very genteel and stuff like that. And it just kills me as someone who spent the last few years actually whining quite a bit about left-wing cancel culture. I think there needs to be some kind of professional cancel culture reckoning, right? I don't want Pam Bondi, right? I don't want us all sit, politely next to Pam Bondi and Todd Blanche at FedSoc meetings, right, and talk about the niceties of this or that, right? I think we are sadly quite past that. But the bigger question will be, how do you rebuild those norms? And that's a question I don't know the answer to.
So let me start with a question for you, Alan, that draws on that culture question, right? You're following the headlines more than I am, but I also had seen something that the DOJ has lost thousands of attorneys, which is a big number, right? Some of them might have been fired. Some of them had written their letter and chose to share their letter. If you're at the DOJ and you really care about the Constitution and the rules of professional responsibility and the culture, do you have a responsibility to try to stay and preserve what you can until you get fired?
I would not pretend to be able to make that choice for anyone. This is an extremely, extremely personal choice. Because on the one hand, I think there is a prima facie case for staying, right? Because I do think well, you think what I did was bad. Imagine the stuff that I managed to avoid is a legitimate argument, frankly. But the personal cost of that is immense, is just enormous, right? You are asking people to work in horrific conditions. You are asking people to take on massive reputational risk. You are asking people for the rest of their career, right, to get dirty looks at cocktail parties, right? It's very easy for me to sit here and self-righteously get on my high horse. It's a nice view, right? It feels great. Because I worked at DOJ, I put in my time, right? I get to say for this my career I was a DOJ lawyer, and I never once had to make a difficult decision at DOJ. I never came within a light year of having to make a difficult decision at DOJ, right? It was hard work, it was intellectually stimulating, blah, blah, blah. I worked really hard, but my God, it was a piece of cake, right? And now I left, right? And I get to sit here as an academic and pontificate about all the things that are terrible that are happening at DOJ, right? So I think it's easy to say, yes, you have an obligation to stay, but the cost of that are enormous. And also, there's a little bit of, to thy known self be true. I forget who did this. I don't know if it was Robert George at Princeton, or it was a famous conservative Ivy League professor who used to like to ask his students, if you had been alive during the antebellum period in the early 1860s, how many of you would have been abolitionists, right? And all the hands go up, right? And then to pause, and it's like, you guys know you're full of it, right? Like, none of you would have been. Maybe one of you would have been. But you are self-selected to be high-achieving, Boy Scouts who are uniquely sensitive to fitting in your social system. Please don't flatter yourself into thinking that you would have taken on the immense social obloquy of being a abolitionist in 1860, right? And his point was not to mock his students. His point was just to kind of build a little bit of humility into them. And so it's very easy. We all think that we will be heroes at the moment of truth, and some of us will be heroes at the moment of truth, and some of us will be cowards, unfortunately. And it's hard to know in advance. Who you'll be. This is why the resignation letter, the pre-writing, is a useful exercise, because it forces you to ask yourself, given what I know about myself, am I going to have the judgment to recognize that I'm being pushed in a bad direction and to blow up my life? So, sorry, this was a very long-winded non-answer to your question.
No,
it's a brutally difficult question, which is why I make it a point to never, ever, ever judge from afar anyone's decision to either stay in a compromised institution or to leave a compromised institution. Obviously, here we're talking about career people, we're not talking about politicals, right? That's a different situation. But for career people, I think it behooves us to never, never, never assume that we understand why they made that decision.
Can I weigh in on this and get?
Please.
I'd like to get on my high horse. I actually think that people of goodwill should not work for the Trump administration. I think that to cooperate with an administration that is so affirmatively lawless and evil, it actually has gone beyond the pale. So I went to a Federalist Society National Lawyers Convention in November of 2016, right after Trump was elected. And all my friends were licking their chops as to what job they would have in the new administration. And I was conflicted at that time. I was thinking, well, I guess we need good people in there to keep things from going off the rails. But now, I actually think things are off the rails, and that the best way you can keep things from going off the rails further is by withdrawing any support or participation or encouragement of the Trump administration. Now, one thing I can urge you is to develop habits of resistance. Those of you who are Christians should incorporate that as part of your nature. It is part of your devotion to Christ to defy all other authority contrary to Christ's command. So I think I've given this same sort of question to students when I've been teaching slavery cases in Dred Scott. And I share the same cynicism that so many students say, I would never, I would never, I would never. But I think it's important to develop within yourselves the ethos of I would never, and then hold yourself to that. Whether that's writing the resignation letter in advance, or just not going near the cliff of falling into supporting an institution that's betraying America. And I say that with some reservation because I have friends. I have good Christian friends, Bible study fellowship members, church members, students, faculty colleagues who support the Trump administration. And, I'm naturally reluctant to confront and antagonize. But I really think it is the obligation of each of us within our personal and professional spheres to put a stake in the ground and say, no, can't support this, can't support you for supporting this. And I say that as a lifelong conservative, pro-life, pro-free market Ronald Reagan Republican who voted for Reagan, Bush,
Romney.
Bush.
We all know you just wrote in Reagan every time. It's fine.
Until we got to the current situation.
Sybil, I have a question I want to ask you that I don't think you've had a chance to prepare for, so I'm hoping you're good on your feet.
I'm a litigator.
I'm trusting. When you were in law school, what do you remember learning about your responsibilities as a lawyer to support the rule of law?
So a couple of things. I went to Vanderbilt, and actually I live in Minnesota because of a professor that I had at Vanderbilt, Susanna Sherry, who was friends with Judge Rosenbaum and sent me here for a clerkship after. And this is a meandering way of answering your question, but as I was interviewing with Judge Rosenbaum, I am, if you look at my resume, the opposite of everything you just described yourself as. But we agree on a lot. And Judge Rosenbaum said to me, he's a Reagan appointee, he looked at my resume and he said, what's a feminazi like you want to work for me for? And Judge Rosenbaum and his history had, Judge Thunheim actually was supposed to go to Congress and talk about sentencing guidelines. And at that point, the sentencing guidelines were mandatory, not guidelines. And he couldn't make it, so we sent Judge Rosenbaum, and Judge Rosenbaum said, I think this is a tragedy. I think people are going to jail for life based on these guidelines, and it's not fair. And these are people who haven't murdered anyone, they just had a lot of drugs, and I don't think it's right. And the Republican Congress at that point went after him. And he had to hire counsel, and they were investigating. And at the end of it, it ended because Chief Justice William Rehnquist said, knock it off, guys, we don't do this. We have an independent judiciary. And so what I learned about the rule of law, and I'm transitioning from law school to working for Judge Rosenbaum, is that we all have an obligation to uphold it. And that when I came to my clerkship, he said, Dunlop, 90% of the problems that you create, you're going to mess up a lot, I can solve with a pen, but you have to tell me. That's your responsibility. If you mess anything up, you have to come and tell me. And I'm going to tie this back now to your last question. I think the biggest, and I did, I messed things up and I ran right in and I said, I think we got this wrong, or, you got to tell him and then he could fix it with a pen. The biggest problem is that if you are in that system, if you are the person at the DOJ faced with a terrible problem, if you're John Dean, right, and you are working as White House counsel during the Watergate era, somebody can ask you to do a cover-up. And when you're in the moment with those people doing the same thing, you might not even realize it's wrong because you're stuck in a moment with people that are all going in the same direction. And John Dean talks about this. He says, I was in the moment, I didn't notice, and then all of a sudden I realized I need to be a key witness in front of Congress and just tell the truth because otherwise I'm about to lie to Congress. But it is so hard when you're in that moment to see it. And I think that what I learned from law school is that when you are nervous, immediately, if you have an ethical decision, get an outsider to weigh in on it. Immediately go to your judge and say, I think I made a mistake. In my law practice now, if I have an ethical dilemma, I don't want to talk to the people on my case. We're all in it together. I want to go to my ethics committee and say, I'm worried about this. Do we have to produce these documents? Do I have to make this argument? Do I have to tell the judge about this case? When you are in doubt, what I learned is get an outside opinion, and I think that's the danger in staying within the system these days, that there's not that outside opinion.
So I'm glad you brought up John Dean. I'm going to have Alan answer the same question in a moment, but he was here. We had the first panel, this was I think 2007 or 2008, and we had a panel with 2 of the Watergate prosecutors and 2 of the Watergate defendants. First time they had been on the stage together. And what I remember about his comment was very similar to what you just described, right?
I heard him here, I stole it.
Okay, well, so the way he described it was slightly different than have your resignation letter. The way he described it was you have to draw lines in the sand in advance. You have to imagine the scenarios and draw the line so you know where the line is. Because if you haven't done that, by the time you figure out where the line is, you're on the wrong side of the line and you're in trouble. Which I thought was just a phenomenal reflection. He was only, I think, 32 when he was dealing with that in the White House. All right, Alan, same question.
Yeah, it's a great question. And I will say I learned almost nothing. I went to a pretty good law school, and I learned almost nothing about this. And I suspect, pardon?
Where was that?
It was Harvard.
Well, that's...
But I suspect that is not unusual, frankly. I don't think law schools generally do a very good job with this. I think that, unfortunately, professional responsibility is not a field that is taken nearly as seriously as it should be. I think that's mostly the fault of snooty doctrinalists like me who, want to write articles about con law theory that, well, my mother reads them, I'm pretty sure about that, but who knows else, right? And I think often professional responsibility is often viewed as an afterthought. It certainly was where I went to law school, and it was not a course that was in any way, that was frankly rigorous, right? And really forced you to grapple with stuff. I would say the one time that I was really forced to confront this was in an international law class taught by Noah Feldman. Nothing to do with this, but at some point we read John Yu's torture memos. And after eviscerating John Yu's torture memos for an hour, he turns around and he says, by the way, everyone get off your high horses because you have no idea the level of pressure that John Yu was under when he wrote those memos. Right? Young guy, surrounded by his legal heroes, and the vice president of the United States is telling him, or vice president's chief lawyer, right, David Addington, is telling him, if you don't write these memos, people are going to die, right? They're horrible memos, and I might have written them as well if I was in that position. I think that gets to Sybil's point, right? And then I also think that neither of the quote-unquote sides of American sort of legal thought has covered itself in much glory, right? When I was in law school, when you talked about the quote-unquote rule of law, it was almost always in the context of some FedSat speaker who was usually quoting Scalia. The rule of law is the law of rules, or the law of, I forget what it was, right? And like, that was good. People were talking about it. I don't think FedSoc has covered itself in glory, frankly, in the last couple of years and the compromises it's had to make. And on the left, there was almost this kind of embarrassment to talk about a concept as bourgeois, as the rule of law, right? Everyone knew that law was mostly a set of hegemonic power relations, used to keep the oppressed down, right? So really, we needed to overcome the law. And so, it was just not great, right? It was not a great environment. And, one difference between law and political science, right, or law and physics, right, or law and, whatever else, is that, law schools are more like divinity schools than they are like anything else, right? Which is to say, they cannot be neutral about their own subject of study, right? It is a vocational school, right? In the way that a Catholic school, or my last name's Rosenstein, a Jewish seminary cannot be neutral exactly about the project that it is engaged in when it's sending people out to teach the good word, right? Law schools are just secular. We're just secular clergy, right? Let's be real, right? In addition to being natural aristocracy, we're mostly just secular clergy, right? We cannot be neutral on the concept of the rule of law. And I fear that over the last several decades, for just a whole host of ideological, institutional reasons, we have lost the ability of how to teach that, while also simultaneously being very careful, right, of having the discipline to not confuse the rule of law with being pro-abortion or anti-abortion or pro-this or pro-that, right? Because that's, of course, the other trap that you can fall into. A joke that was often made about Ronald Dworkin, one of the behemoths, or absolute behemoths of 20th century legal thought, right, was that, at the end of every one of his extremely philosophical analyses of the Constitution, it turns out that the right answer was whatever the contemporary Democratic Party platform was, right? And so, again, about the danger of confusing, no matter one's own brilliance, what the law requires with what one wants the law to be. But the alternative is, being neutral, and then it's not a great place.
That's it for my questions. Any questions from the crowd?
Jump in with a
Please do.
Point of personal privilege. At the risk of opening up a completely collateral intramural dispute, I think the memos written by John Yoo and Robert Delahunty concerning the lawfulness of the coerced interrogations and the inapplicability of the Geneva Conventions to al-Qaeda were actually legally sound. I don't agree with every argument presented, but I've defended them publicly. So we can go at it on that. But I just didn't want to leave that sitting. Maybe that's a relevant point too, right? You can't, to leave something sitting and to go along is the first step to accepting things and doing things you don't agree with. So I set hedges around my hedges around my hedges is like, if my friend Alan Rosenstein and my friend Richard Painter say something that I disagree with and I think is important, I'm going to view it as my responsibility to...
We're going to go out back after this and decide this.
Okay, there we go.
Question in the back, yes.
Speaking of Richard Painter.
Shouldn't have raised it.
to stand up and point out that, for example, the President of the United States or the Vice President should not leave with classified documents knowing that, and then claim that he's entitled to a second term as President of the United States. Even though he had done that knowingly, removed classified documents, he spoke with his autobiographer about that. What was going on with Hunter Biden and selling artwork was nothing like the Trump boys. It's just the Trump boys know how to do the same thing much more effectively, making thousands of times as much money. But who was speaking out on the Democratic side with respect to that? Or the relationship between Joe Biden and the University of Pennsylvania and the Penn Biden Center, where some of the classified documents were discovered. And of course, the president's state of mind, an issue I repeatedly talked about in the first Trump administration and the question of the 25th Amendment. But now, I find very few Democrats who want to have that conversation about President Trump and his second administration, and I wonder why. So is it not the truth that in both political parties, partisans circle the wagons around the President of the United States, whether the president's sins be relatively small, but serious in the case of President Biden, or much more serious in the case of what we have going on right now?
Take a stab? Or you?
No, you go first. I've been talking a lot.
No. So, again, I'm a practitioner, so you're going to get the practitioner answer. I teach bias, and so we know that we all have confirmation bias. It takes more evidence of anyone on any one side to convince someone that there's something wrong than if you already believe the opposite position. So presumably it would take the Democrats more evidence to believe that something wrong had happened, and the flip side on anyone who believes the other side coming into it. As someone who is very wary of confirmation bias, I always think, what checks can we put in the process to make sure that doesn't happen? It's important, right? We want to make sure we're fair. And there are people in our system who are supposed to be those checks. I think Justice Scalia is amazing at being consistent, I think, or attempting to be consistent in his positions, regardless of which side they come down on. He tries to have a consistent approach to things. What gets me worried is when those, and the general public, we're just going to be biased, I think, in general. We know we have confirmation bias. We're fed it by the media that we're selecting, et cetera. But when it matters, I think it matters with judges. And so the thing that has me most concerned is when our judges are flip-flopping. So when we're judging Biden by a different standard than Trump. I was worried, frankly, looking at the recent tariff oral argument, that we were doing a little bit of that, but we'll see how it comes out. And so I think the question is correct. We want to all hold ourselves accountable, to hold people equally, to treat people fairly. I try and do it. So when I am in the minority on this one, but I will give an example. A lot of folks in our party, when news came out that Al Franken had perhaps not been treating women fairly, were willing to look a blind eye. And I wasn't. I said, he's not going to be as effective. Not that, it's up to the courts to decide what was illegal, but I didn't want him still representing me or my party. It's a place where I felt like I could be consistent in my beliefs and hold them accountable. So I think as lawyers, our job is to say, what is my role in the system, and am I doing this fairly? Am I applying it in the way I would, and how can I eliminate confirmation bias? Because I think you're right. We have to make sure we're doing it. But I am particularly worried about judges in this moment not applying it fairly.
Yeah, I agree with all that, and I think, Richard, you make a very good point. I don't think the Democrats have covered themselves in particular glory. I think it's important to avoid false equivalence, but nevertheless, it is the case that plenty of what Biden did was quite problematic. And I think things like, for example, the what I thought at the time was patently unlawful student loan attempt to eliminate a bunch of student loans, and then pardoning his son. This bizarre attempt to announce that the Equal Rights Amendment was ratified. Like, this is weird stuff. And then there were sort of other things happening, with some Democrats that were really problematic. Look, right now, I mean, as far as I can tell, the prosecution against Letitia James is a kind of an embarrassment. But let's not pretend that she is some sort of rule of law hero either. Several years ago, she tried to dissolve the NRA. Not just punish Wayne LaPierre, but literally dissolve the institution, because at the time, and it was quite obvious, she, who's very much against gun rights, saw that the NRA was in a very vulnerable state and decided that the litigation at the time gave her an opportunity to mortally wound it. And I wrote a piece for Lawfare at the time, and I am about as anti-gun rights as you can imagine, right? Saying this is insane. You cannot do this. The NRA, right, is a core part of American public fabric. Millions and millions of people rely on it to defend their view of their constitutional rights. The fact that Wayne LaPierre is a fraud and a crook is bad, so get rid of him. But this is appalling, right? And I wrote that with some trepidation because I figured I was going to get a lot of incoming from people on quote-unquote my side. But to your point earlier, Mike, you have to build habits of courage, right? And I say that because I am by nature a giant coward, right? Like, I know myself. I am an absolute pathological, conflict-averse coward, right? And the way that you deal with that is by exposing yourself to small increments of absolute sheer terror. And writing that piece was terrifying because I figured I was going to piss off all my friends. Turns out no one reads my stuff anyway, so it didn't matter. But you do that, right? Yeah, exactly, my mom. My mom liked it. You do that precisely in those moments to, teach yourself that, you can be a little bit courageous in moments. But yes, absolutely right. It is a huge blind spot. I mean, I will say, I think the original sin, frankly, is the Clinton impeachment, right? I think the original sin of a lot of this, actually, right, is not just maybe the acquittal, but the hordes, the absolute army, right? And I'm so curious what life was like for you in the late 90s, Mike, on this. The absolute army of kind of elite liberal law professors that came out of the woodwork, right, to say, whatever, none of this is a big deal, right? There's been a lot of retconning of that.
What does that mean?
Retconning, it's a term where you kind of, memory holing. That's a term I'm looking for, right? Pretending, right, that a lot of people didn't overlook, what I think in retrospect pretty clearly should have been an impeachable and removable offense, right? And I'm not saying that because they didn't remove Bill Clinton, we got Donald Trump, but I do think a certain sense of moral seriousness of the presidency was demolished in that moment in a way that made it that much easier for someone like Donald Trump to sail through.
I don't have any particular courage. I just have no friends to offend. On the Clinton impeachment, I did write an article 25 years ago, if you want to look it up, called Nixon Now, the Courts and the Presidency After 25 Years. I can find you the site, but I say, a likely consequence of the Clinton acquittal on partisan grounds will be that the next time this comes up, a president will say, I can beat it with as long as I maintain the political support, and it will be a permanent downgrading of our moral and political standards. I think I was right.
And that's a good note to end on. Mike Paulson is right.
First, I want to give a sincere thanks to Professor Michael Paulson for bringing this event together. Today's outstanding lineup, and also for contributing his own presentation in multiple of the presentations, so thank you so much. The speakers that we had today were truly top-notch, and truly it demonstrates the quality of Professor Paulson and his network and his career. So can we please give a big round of applause to Professor Paulson? I also want to thank a lot of the administration who helped behind the scenes. Gloria Meyer, the Director of Alumni Engagement and Student Life, Carrie Hilger, the Marketing and Communications Director, and Devin Donskoy, the Events Manager. They coordinated this beautiful space, and they also helped me every step of the way stay accountable and not get behind. Very helpful. Our tech ran flawlessly thanks to Xander in the back. And catering. Thank you to the catering team for breakfast and lunch. And also thank you to City McGrath for helping with the budget throughout. To the St. Thomas Law Journal, I want to thank you for your professionalism and your great questions throughout the symposium today. And I want to thank the speakers. It was a great opportunity to have you and have voices across the profession from academia to practice. So thank you for your time, your candor, and your scholarship. Thank you all for coming.
Thank you.